is in judicial custody since 2018. 21/18. Incident took place on 16. Then Lordship PW1. PW1 Lordship is son of accused and page 7 Lordship. Next page. He's Dhruba Bauri alias Ratan Bauri. His age is not mentioned. He's a minor Lordship.
He's 9 years.
Or above that, but about his age Lordship, his father is saying he's 8 years, but here it is 9 years, so he was a minor witness. And some questions were put to him to judge him, Lordship. What is your name? My name is Sri Dhruba Bauri alias Ratan Bauri. The question, do you go to school? Yes, I'm studying in school. In which class do you read? I read in class 4. What is the name of your school? My school name is Gereki Sarkari Nimna Bunyadi Vidyalaya. After examining the witness, I have found that he is capable of giving rational answer, and as such, I certified that he is competent witness, and as such, I have recorded his evidence without administering oath. What he says, Lordship, is that the accused is my father, deceased Jonta Bauri was my mother. About 4 months ago at night, at about 1:30 a.m., my father, the accused, had killed my mother by strangulation. I was in the house and I saw my father killing my mother. I made halla, and then my aunt, Pehi. Pehi means husband's sister. Jonali Guha came out of her house, which is adjacent to our house. My aunt also made halla. Other people also gathered. The villagers tried to save my mother by providing heat of fire. On the next morning, police came and took up the dead body for post-mortem examination. Police arrested my father. Police brought me to the court, and accordingly, I have given statement under section 164 of CRPC before magistrate. Exhibit 1 is my statement, wherein exhibit 1:1, 1:2, and 1:3 are my signatures. That, Lordship, is his 164 statement is in page 33 to 35, Lordship. In cross, he says, I usually go to sleep at 7 p.m. Quarrel occurred regularly between my father and mother. It is not a fact that I have stated falsely that my father had killed my mother by strangulation. It is not a fact that I have stated falsely as tutored by my aunt and uncle Pehi and Peha. On that day, I went to bed at 7 p.m., but at the time of incident, A woke up. It is not a fact that I have not seen the occurrence, and I have stated as tutored by my aunt and uncle Pehi and Peha.
So this once more, Pehi is what?
Pehi is father's sister, and Peha is her husband. He becomes brother-in-law. This Peha filed the FIR, Lordship. So he is the only witness, Lordship. Naturally, he was in the house who saw the whatever he's saying. That is the PW2 is Jiten Guha. He is the Pehaman's brother-in-law of the accused, and he is also the scribe of the FIR, Lordship. He filed the FIR. His evidence is next page, Lordship, page 8. I know the accused. I knew deceased who was wife of the accused. The occurrence took place about 4 months ago. At about 1 a.m. in the morning, the PW1 made halla. My house is situated about 30 feet from the house of the accused. Hearing the halla, I went to the house of the accused and saw that Jonta Bauri, the wife of the accused, was lying on the ground inside the house. The PW1 told that his mother was killed by his father, the accused by strangulation. We have called the other villagers, and on the next morning, police came and took up the dead body for post-mortem examination. I have not seen the accused at that time. I lodged an FIR before Sutia PS Exhibit 2 is the FIR, wherein Exhibit 2:1 is my signature. Police had prepared inquest upon the dead body. Exhibit 3 is the inquest wherein Exhibit 3.1 is my signature. I have not noticed any injury upon the dead body at the time of conducting injury. This will be, Lordship, vital, but the child said that she was strangulated, but this person who was he signed in the inquest report, he says that he did not see a mark of any injury on her. Cross by defense. I have not seen the incident personally. I have put my signature on a carbon copy, the Exhibit 3. I have got no personal knowledge as to how Jonta Bowry died. I came to know about the occurrence only as per the version of PW1. So that is his hearsay because he heard it from the son only. In fact, all the witnesses, Lordship, will find that they heard it from, because naturally it happened in the house of the accused and the deceased and the children. And my argument, Lordship, is basically that I'm not going to deny because there is no explanation. But then, Lordship, since there was a quarrel, so I would like to the exceptions to 300, Lordship. If it can be mitigated that way. PW3, Bokul Karmakar. I know page 9, Lordship. I know the accused who is my neighbor. I knew deceased Jonta Bowry, who was the wife of the accused. The occurrence took place about 4 months ago. It was a Bihu time, that is Aghon Jatra. The accused enjoyed Aghon Jatra and consumed liquor, and thereafter he came to the house. At about 1:30 a.m., the son of the accused made halla, and hearing halla, I went to the house of the accused and saw that Jonti Bowry was lying dead inside the house of the accused. PW1 told me that Jonti Bowry was killed by his father, the accused, by strangulation. Thereafter, many people gathered. On the next day, police came and took up the dead body for postmortem examination. In cross, he says, I have not seen the incident personally. I have got no personal knowledge as to how Jonta Bowry died. I came to know about the occurrence only as per the version of PW1. And Lordship, PW4, page 10, Lordship, is Jonali Guha. Jonali Guha is the Pehi, Lordship, the sister of the accused. Informant Jiten Guha is my husband. Accused Biren Bowry is my elder brother. The incident took place during the last Magh Bihu, a harvest festival celebrated in Assam in the month of January. About a month prior to the incident, Biren Bowry went to Balijuri for work. 3 days before the Bihu, the accused returned. Quarrels took place between him and his wife frequently. On the day of this is important, Lordship, because this I'm going to use in my argument for that mitigation, Lordship. Quarrels took place between him and his wife frequently. On the day of the incident also, a quarrel took place between them. On that day, my elder brother assaulted sister-in-law, Junta Bowry. The son of my elder brother is Dhruba Bowry, who is aged 10. First, he told our fellow villagers that his father had strangled his mother to death. Then he informed me about the incident. Police questioned me. At present, both the children of my elder brother are staying with me. In cross, she says, Lordship, the courtyard of my residence and that of my elder brother is the same. Kushal Rajbor and Babul Karmakar stay nearby. The house of my elder brother is a concrete one. It is a tin-roofed house. I reached after the incident had taken place. When I reached, sister-in-law was all right. Now, this witness is saying that, Lordship, sister-in-law was all right. Thereafter, I did not witness any incident. This is vital, Lordship, because she is neighbor, and then she's saying that sister-in-law was all right. There is no electricity in the house of my elder brother. It is a house having 2 rooms. The children were present. At about 3 or 4 a.m., I went to the house of my sister-in-law and saw her dead body lying on that place. Today, I have deposed on the basis of the information given to me by my elder brother's son. When I reached my elder brother's house, after being called by the son of my elder brother, I didn't find my elder brother there. I didn't tell police that Dhruba Bowry had told me that his father had strangled his mother to death. So this is the contradiction between 161 statement and what she is saying in her cheat. It is this sentence, Lordship. It is not a fact that the accused did not kill my sister-in-law. It is not a fact that my statement is based on hearsay. At first, when quarrel took place, I dissuaded them from quarreling. So there was a quarrel, Lordship. That is from the sons, even if we take that only one witness was there, the son, he also said that there was quarrel. And then the quarrel used to happen in regular, it was a regular feature. That's the evidence. But here I find something disturbing. What she is saying is that when Iri's sister-in-law was all right. Thereafter, I did not witness any incident. So that part, Lordship, is it's not matching with the other, what the PW1 is saying. PW5, page 12, Lordship, is Jagadish Naik. I know informant Jiten Guha, I also know Hiren Bauri. About 6 months ago, when I went towards the residence of Hiren Bauri, I saw police. The police said that the dead body lying inside the house of Hiren needed to be taken out and asked that if we, as fellow villagers, didn't take out the dead body, who else would do so? The dead body was on a bed inside the house. It was the dead body of the wife of the accused. I don't know the name. I didn't see any injury on the dead body. After the dead body was brought outside, police asked me to leave, and so I left the place. The accused was not present in the house at that time. The accused had wife and 2 children at home. One child is aged 10, while the other is 7. Police didn't question me individually. Then in cross, he says, I don't know the incident, how the incident took place. He is a driver, Lordship. Just, I think he helped in bringing out the body only, nothing else. PW6 is Krishna Bauri, Lordship. I know, page 14. I know accused Hiren Bauri. I also know informant Jiten Guha. The incident took place on 16/1/2018. We were not present near the place of occurrence on the day of incident. Reaching the village on the following day, I came to know that Junta Bauri, he is also hearsay, Lordship. The wife of the accused had died. I came to know from the villagers that accused had murdered his wife. Police had not questioned me anything specific. They asked me only my name. In cross, he said, I don't know the villager who informed me of the incident. The accused was suspected to have killed his wife. So he is adding a word suspected, Lordship. Then PW7 is Kushal Das, page 15, Lordship. I know informant Jiten Guha. I know accused Hiren Bauri. I was not present at the time of, he is also hearsay again, incident. The incident took place in the year 2018. I was in Arunachal at the time of incident. My wife informed me over phone from home that my sister-in-law, her elder brother's wife, had died and that she died following her quarrel with the accused. Fight took place between them. Later, I came home at the time of Shraddha, religious ceremony held in the honor of the deceased. In cross, he says, my wife made a phone call to me on the day of occurrence itself. She made the phone call in the morning. She called me suspecting that the accused had committed the murder. PW8, Lordship. These all are hearsay only. PW8 is Moonnath. I know informant Jiten Guha. I also know accused Hiren Bauri. The incident took place in January 2018. There had been frequent quarrels between the accused person and his wife. This quarrel, Lordship, is coming in every year. These are all villagers. The PW2 and 3 are related, but others are, they live nearby. The quarrel thing is coming with every year. Though they are saying that we have not seen that, but they used to quarrel. That thing is coming with every witness. On the following day of occurrence, I came to know that the accused person had killed his wife, Junta Bauri. The incident had taken place in the night, and I came to know about it in the following morning. Hiren's mother, she is dead now, and Hiren's children were there at the time of they have left out. In cross, he says, I don't know about the incident properly. I learned about the incident when some people told about it. PW9 is the IO, Lordship, investigating officer. On 17/1/18, his ASI Mohan Chandranath. On 17/1/18, I was officiating as Saristadar in Sirtia Police Station. On that day, OC Manoj Borua received an ejahar, and upon registering a case on the basis of that ejahar, he entrusted me with the charge of investigation. Taking the charge of investigation, I went to the place of occurrence, that is Geriki Gaon. At the place of occurrence, I found the dead body of Junta Bauri lying on the ground inside her house. I examined the witnesses there. I sent the dead body for postmortem examination. Now, Lordship, this next sentence is very important. He says, I recorded the statements of the witnesses. I recorded the statements of the witness Ratan Bauri under section 164 CRP. How can he record? That is what he's saying.
Records are here.
That statement
records are
is,
here.
yes, records are here. That statement, Lordship, 164 statement, Lordship will find it page 33 to 35.
All in burning color, no?
Though there is signature, this signature of judicial magistrate first class is there, Lordship.
Just a minute.
Yes, Lord.
This witness. 9.
PW 9.
It is recorded by the magistrate itself. It's there in the paper book. It is NXT 164 statement at page 33. It will be there, the original. JMFC Pooja Sinha recorded.
Oh, no. Position of, oh, this is a, from that, PW 9.
पुलिस से लिखते हैं पुलिस से लिखते हैं
मैं कोई सो अच्छा কিন্তু কি কব কিয় কি কব
The original. Can you read this one?
I can read, but
It's in vernacular.
Oh, it's in vernacular.
Can you just check up?
Yes, yes, I'll
Just
check up. Perhaps Lordship understand Assamese. If I read out, Lordship will understand.
No, it's quite difficult for me.
Acha, acha.
We'll-
so I'll translate. You read it, I'll
maybe my
translate
brother
it.
can
Justice AT must be knowing Assamese. I'll read out. This handwriting is also very bad. Oi.
Laptop in a one.
Lordship wanted me to read out the IO statement, whether,
Yeah.
yes, that relevant part. Bonale.
With regard to 164.
With regard to 164, Eight was Assam. I can read good Assamese handwriting, but this is too bad. 164.
নহয়
এইখিনি।
তাৰ আগত আছে
Oh, yes, yes. Eight was below. Horrible handwriting, well. I'll try. Hakir Sensor. এইখিনি কৰিলে হ'ব দে জবানবন্দী 164 CRPC লিপিবদ্ধ কৰা
Oh, is
এই
that-
আগৰটো সাক্ষী ৰতন কিবা নেকি ৰতন
ৰতন বাউৰী
বাউৰীৰ জবানবন্দী
164 CRPC under লিপিবদ্ধ কৰা।
Yeah, the same.
তেওঁৰ
Whatever-
বয়স 11
Nah,
মান
Hobo. Down with 164, he cannot do no.
That is
Ministry can do,
হা হা
but he is saying that he has recorded it. This is wrong, but then
it
And
will
who has
be
recorded it?
translation of
ministry.
yeah
It was mistakenly written perhaps, but the same. Whatever is translated, this is same.
That's it.
So, Lordship, the exhibit the 164 statement here signature is there, that magistrate
Page
judicial
36.
yes 34 is the relevant part of it. But the thing is, but this witness, because this magistrate was not called, Lordship, to the court, she was not a witness, and this IO has said that I recorded it. So I'm just pointing out like that part. And actually, since we are at page 34, Lordship, let me also read this 164. This is also vital because his evidence and this part, there are certain mismatches. He was asked the questions. I'll read just the relevant part. On the questions put and answers received, it is found that the witness has a good understanding of things and hence his statement is recorded. At about 2:30 a.m. last Monday, my father, Hiren Bauri, came home under the influence of liquor and assaulted my mother. My father kicked my mother a lot and pulled her by the hair. I saw the incident. My mother fell down on the ground. My mother was lying on bed in the house. My father was at home. Later, my mother died in the night last Tuesday. I screamed and then my father told that he had not strangled my mother to death. Later, my mother died. That was all about the incident. My father used to assault my mother. This is his 164 statement. This is what he says there. Then, Lordship, I'll continue with the IO statement.
Yes.
Page 17. I recorded the statement of witness Ratan Bauri. And he is about 11 years old. I arrested accused Hiren Bauri and forwarded him to the court. I drew the sketch map of the place of occurrence. Exhibit 4 is the said sketch map, and Exhibit 4.1 is my signature therein. On completion of the investigation, I submitted the charge sheet against the accused person under Section 302 IPC. Exhibit 5 is the charge sheet, and 5.1 is my signature therein. In cross, he says, I reached the place of occurrence at about 7:15 a.m. on 17/1/2018. I got the inquest held. This is also again vital, Lordship. I got the inquest held. Letter says, I did not get the inquest report prepared through executive magistrate. He himself, what he is submitting, Lordship, he himself did the, because it is the executive magistrate who is supposed to do the inquest, Lordship.
Even police can do.
Huh?
Police can also.
Executive magistrate, no.
Nah, police can do.
Because I'm just pointing out.
No.
Though senior officer did not go along with me at the time of investigation, I conducted the investigation as per the instruction and advice of the OC. Ratan Bauri was present at the time of the incident. It is not a fact that I don't have legal authority to carry out investigation into a case. It is not a fact that I don't have authority to submit charge sheet in this case, and that I have carried out the investigation in this case illegally. It is mentioned in the case diary that OC handed over the charge of the investigation to me. Then, Lordship, next page, page 19 is the PW10, the doctor who did the postmortem examination. On 17/1/18, I was working as MH and HO1 at Kanaklata Civil Hospital at Tezpur. On that day, I examined Junta Bauri, female, 35 years, being identified by UBC 773 Jakia Hussain with reference to Satya PS case number 9 of 2018 under section 302 IPC. On examination, found dead body of average built lady of age around 35 years was examined. Rigor mortis is present. Superficial bruising and aberrations are seen over the face, forehead, neck, both arms, and over abdomen. Bruises also seen over the knee and right leg. Fingernail abrasion seen on the neck, over left carotid and left side of mandible. On dissection of neck, engagement seen. Extensive bruising seen on the neck muscles. Frictional bone fracture seen. Fracture laryngeal and thyroid cartilage seen. On examination of cranium and spinal cord, scalp is congested, congestion present in the brain tissue. On examination of the thorax, pleural congestion seen, laryngeal and tracheal ring fracture, both the lungs are congested. On examination of abdominal, superficial abrasion seen on the abdomen. Internal and external sexual organs are healthy. Uterus cavity is empty. Signs of asphyxia are seen in both the internal and external organ of respiration. Scratches and bruises are seen over the face and neck and arm. Changes are antemortem in nature. Time since death 6 hours to 24 hours. In my opinion, the cause of death is due to asphyxia as a result of throttling. Exhibit 6 is the postmortem report. Exhibit 6.1 is my signature. In cross, he says, after examination of the dead body, I have prepared my report in rough and thereafter copied the same in the postmortem report. I have not submitted my rough prepared with this report. I have not mentioned the date of inquest report on the PM report. I have not prepared the PM report on the basis of the inquest report. Now, this line is important. Whenever a dead body is taken for postmortem from the place of occurrence, bruises may occur on the body. So about the bruises, Lordship, the other witnesses, they said, and even the person who signed the inquest report, he said he did not see any injury. These bruises, Lordship, from where did they appear? Because some were on face, it can be easily seen. But none of the other witnesses have said that those bruises. And the explanation this doctor gives that whenever a body is taken for postmortem from the place of occurrence, bruises may occur on the body. Then, Lordship, the accused was examined. He was denial, total, he has denied everything. And then he was convicted for life and also fine of 2,000 rupees or to undergo rigorous imprisonment for 1 month, Lordship. So now, Lordship, I have given a list of cases, Lordship. 2 cases I'm relying on because what I am trying to show, Lordship, is that it will fall under the exceptions because, Lordship, the quarrel thing, they used to have quarrel. It's mentioned by all the witnesses. And on the night of occurrence, even if we go by the evidence of PW1, Lordship, they had quarrel. Lordship, for section 300 murder, Lordship, the exception, there are 4 exceptions. Exception 1 and exception 4, Lordship, are more or less same kind. One is deprived of self-control, exception 1, and exception 4, without premeditation, that without any preparation, Lordship. Lordship, exception 1, when culpable homicide is not murder. Culpable homicide is not murder if the offender, whilst deprived of the power of self-control by grave and sudden provocation, causes the death of the person who gave the provocation or causes the death of any other person by mistake or accident. And exception 4, Lordship, culpable homicide is not murder if it is committed without premeditation in a sudden fight in the heat of passion upon a sudden quarrel and without the offenders having taken undue advantage or acted in a cruel or unusual manner. So, Lordship, here the injury was that he has strangled his wife. That is the main cause of death, that she died because of that. So my humble submission, Lordship, is that his conviction, because there was a quarrel, and then he, because of in the heat of passion, he did that. And some of the witnesses also said that he had consumed liquor because there was a festival. So basically his mental condition was not fully, and when there was a fight, Lordship, in that he killed his wife. And Lordship, this Dovaram Nirmalkar case, Lordship, versus State of Chhattisgarh. Relevant paragraph, Lordship, because 26, Lordship, last in the end, Lordship. Because in this case, early the accused had taken the plea that it was a private defense, but the apex court said that no, private defense won't be there. Then, Lordship, paragraph 26, the court then said, the question now, Lordship.
Which one?
Oh, sorry, Manjeet Singh, Lordship.
Singh.
Yes, Manjeet Singh. It is a full bench judgment. Lordship.
Paragraph 26.
26, Lordship. The question now requires to determine is as to what is the nature of offense that the accused has committed. The evidence produced against the accused does not show that the accused had any motive to cause death of the deceased or have intended to cause such bodily injuries, which were sufficient in the ordinary course of nature to cause the death of the deceased. Evidence on record also does not establish that the injuries caused on the body of the deceased must in all probability cause his death or likely to cause his death. On the spur of the moment, during the heat of exchange of word, accused caused injuries on the body of the deceased, which caused his death. Therefore, the ingredients of the murder as defined in section 300 Indian Penal Code have not been established against the accused. In our opinion, the accused was guilty of culpable homicide not amounting to murder under section 304 Indian Penal Code, and considering the fact that the accused had no intention to either cause the death of the deceased or cause such bodily injury as is likely to cause death of the deceased, it would be sufficient to impose on accused a sentence of 7 years rigorous imprisonment, or to impose on him a fine of rupees 5,000, and in default payment of fine a further imprisonment of 6 months. Lordship, even the child, Lordship, in 164, he says the father said that I have not strangulated. So his intention, maybe in the fight he did the action, but his intention to kill her is not established, Lordship. That mens rea is absent, Lordship. And the other case I'm relying on, Lordship, is this is criminal appeal, Dovaram Nirmalkar versus State of Chhattisgarh, Lordship. The relevant para, Lordship. Paragraph 9. And in this Nanavati case was also discussed in this case, because Lordship knows Nanavati case, the husband had killed the lover of the wife. The court held that the provocation can be from time to time. It can again culminate in bigger EA. So Nanavati case, in this case, that was discussed on that point, Lordship. And here also, in our case, Lordship, they used to have fight. That is, they used to quarrel. That is there with every witness of the village have said that. Even PW1. Paragraph 9, Lordship.
Yes.
Exception 1 differs from exception 4 of section 300 of the IPC. Exception 1 applies when due to grave and sudden provocation, the offender deprived of the power of self-control causes the death of the person who gave the provocation. Exception 1 also applies when the offender, on account of loss of self-control due to grave and sudden provocation, causes the death of any other person by mistake or accident.
Yeah.
Exception 4.
Something is missing here. After that, exception 1 also, then there's nothing.
Exception 9, paragraph 9, Lordship.
Yeah, paragraph 9, we just have 4 lines.
Yes, 4 lines. After the next page is there, Lordship. Page 8. After that, Lordship, this is written about exception 4. This is from the section itself, it is quoted down below.
After that, it's only para 10.
Yes.
Yeah.
Paraten.
Oh, I do not know. He made the copies, Lordship. Oh, that means from after exception 1 also the sentence is not complete.
Not complete.
Oh, he made the copies, Lordship. I gave him the list.
You have a cross reference with SCC. SCC.
SCC, it was reportable. Dovaram Nirmalkar.
AI design.
No, no, more criminal appeal, more direct
what is the name?
reportable into report which is
Dogaram Nirmalkar.
was the state of the I'll also check. It is reportable, so maybe it is reported. A judgment was tomorrow. Here it. 2nd August 22.
AI 2022, SC 3620.
Lordship got
AI.
On the top.
On top. AIR 2022, Supreme Court,
yeah.
2022, Supreme Court, 3620.
India plan on all this. Thing is not.
Nah, yeah. I said,
AI citation of assist.
more one.
Citation nine.
Nah, me too, that download one.
Citation in the AIR only is available. I don't think so. It's reported in the SCC.
AIR
SC 83620.
868.
Huh?
3620 no 8
AIR
oh yeah 368
36.
9.
And it is same even in the AIR. It is same exception 1 also, and the sentence ends.
is it?
Yeah, in AIR also. I've taken it out from Manupatra. And same thing. And then paragraph 10 starts.
Oh, but the court, this is I have taken directly from the Supreme Court's yeah, lordship. So then that means that's a citation bhul koriche. Because sentence it cannot change, it cannot end there. Exception 1 also it continues, applies when the offender.
Oh, it continued there.
Is what? It
One
cannot
also,
be
then?
it was section applies when the offender. You know, paragraph
Oh, like 19.
they missed out the paragraph. But
Ah.
basically, Lordship, what it is discussed is the difference between exception 1 and exception 4 in this paragraph. The way I read, Lordship. There is slight difference, but basically, provocation. Provocation is part of these two exceptions, Lordship. Then, Lordship, then the court discussed about Nanavati case, because Nanavati case, the uh, the uh, the provocation. Court had discussed about the provocation. Provocation can be of a long time. That and then Lordship, paragraph 12 starts from the question of paragraph 12. The question of loss of self-control by grave and sudden provocation is a question of fact. Act of provocation and loss of self-control must be actual and reasonable. The law attaches great importance to two things when defense of provocation is taken under exception 1 to section 300 of the IPC. First, whether there was an intervening period for the passion to cool and for the accused to regain dominance and control over his mind. Secondly, the mode of resentment should bear some relationship to the sort of provocation that has been given. The retaliation should be proportionate to the provocation. The first part lays emphasis on whether the accused acting as a reasonable man had time to reflect and cool down. The offender is presumed to possess the general power of self-control of an ordinary and reasonable man belonging to the same class of society as the accused, placed in the same situation in which the accused is placed, to temporarily lose the power of self-control. The second part emphasizes that the offender's reaction to the provocation is to be judged on the basis of whether the provocation was sufficient to bring about a loss of self-control in the fact situation. Here again, the court would have to apply the test of a reasonable person in the circumstances while examining these questions. We should not be short-sighted and must take into account the whole of the events, including the events on the day of the fatality, as these are relevant for deciding whether the accused was acting under the cumulative and continuing stress of provocation. Gravity of provocation turns up the whole of the victim's abusive behavior towards the accused. Gravity does not hang upon a single or last act of provocation deemed sufficient by itself to trigger the punitive action. Last provocation has to be considered in light of the previous provocative acts or words serious enough to cause the accused to lose his self-control. The cumulative and sustained provocation test would be satisfied when the accused's retaliation was immediately preceded and precipitated by some sort of provocation conduct which would satisfy the requirement of sudden or immediate provocation. Thus, the 13th paragraph. Thus, the gravity of the provocation can be assessed by taking into account the history of the abuse and need not be confined to the gravity of the final provocation act in the provocative act in the form of acts, words, or gestures. The final wrongdoing triggering of the accused's reaction should be identified to show that there was temporary loss of self-control and the accused had acted without planning and premeditation. This has been amply summarized by Ashworth in the following words. The significance of the deceased final act should be considered by reference to the previous relationship between the parties, taking into account any previous incident which add color to the final act. This is not to argue that the basic distinction between sudden provoked killing and revenge killing should be blurred, for the lapse of time between the deceased final act and the accused's retaliation should continue to tell against him. The point is that the significance of the deceased final act and its effect upon the accused, and indeed the relation of the retaliation to that act, can be neither understood nor evaluated without reference to the previous dealings between the parties. Exception 1 to section 300 recognizes that when a reasonable person is tormented continuously, he may, at one point of time, erupt and reach a break point whereby losing self-control, going astray, and committing the offense. However, sustained provocative principle does not do away with the requirement of immediate or the final provocative act, word, or gesture, which should be verifiable. Further, this defense would not be available if there is evidence of reflection or planning as they mirror exercise of calculation and premeditation. In our case, Lordship, there is nothing brought in that he had pre-planned the killing. There was a fight, there was a quarrel between, and the witnesses have said that in past also they used to quarrel. So this thing fits in that. Following the view expressed in K.M. Nanavati, this court in Buddhi Singh versus State of Himachal observed that in the test for application of exception 1 to section 300 of the IPC, the primary obligation of the court is to examine the circumstances from the point of view of a person of reasonable prudence. If there was such grave and sudden provocation as to reasonably conclude that a person placed in such circumstances can temporarily lose self-control and commit the offense in the proximity to the time of provocation. A significant observation in Buddhi Singh is that the provocation may be an act or series of acts done by the deceased to the accused, resulting in inflicting of the injury. The idea behind this exception is to exclude the act of violence which are premeditated and not to deny consideration of circumstances such as prior animosity between the deceased and the accused arising as a result of incidents in the past and subsequently resulting in sudden and grave provocation. In support of the aforesaid proposition and to convert the conviction under section 302 to section 304 part 1 of the IPC in Buddhi Singh, the court also relied upon Rampal Singh versus State of Uttar Pradesh. 15. For clarity, it must be stated that the prosecution must prove the guilt of the accused, that is, it must establish all ingredients of offense with which the accused is charged. But this burden should not be mixed with the burden of the accused of proving that the case falls within an exception. However, to discharge this burden, the accused may rely upon the case of the prosecution and the evidence adduced by the prosecution in the court, Lordship. Here also, Lordship, the accused did not adduce any evidence on it, but what my argument is based on the evidence adduced by the prosecution itself. The witnesses, they are talking about the quarrel between the husband and wife, frequent quarrel. And on the night of the incident also, there was a quarrel between the PW1 son. He is also saying that. On the night of occurrence, the deceased had, however, to discharge. It is in this context we would refer to the case of the person, which is that the deceased was addicted to alcohol and used to constantly torment, abuse, and threaten the appellant. On the night of occurrence, the deceased had consumed alcohol and had told the appellant to leave the house, or if not, he would kill the appellant. There was sudden loss of self-control on account of slow burn reaction followed by final and immediate provocation. There was temporary loss of self-control as the appellant had tried to kill himself by holding live electric wire. Therefore, we would hold that the act of provocation on the basis of which the appellant caused the death of his brother, Dashrath Nirmalkar, were both sudden and grave, and there was loss of self-control. Applying the provocation exception, we would convert the conviction of the appellant from section 302 to part 1 of section 304 IPC. My humble submission is also that, Lordship, in the present case before Lordship, the conversion, I'm not saying that he did not do because it was in the house, but then the deceased also contributed towards the incident, Lordship. That is my humble submission. And Lordship, part 1, I'm not even saying it should go to part 2 of 304. I'm saying part 1 of 304, 10 years, Lordship, that can be, that will be, I think, Lordship, sufficient. And then also we have to consider that 2 children are there, Lordship. Mother is dead and the father is in jail, Lordship. Five years he has completed, I think, Lordship, because if we go by the paper book, in January from 2118 he was there. So this January he completed 5 years. So some 5 more years he can stay, Lordship. That is my humble submission. Can convert it.
May please, Your Lordship. In fact, the homicidal death in the hands of the accused, my learned friend has not have not disputed. And it is rightly so, because the son, although Lordship knows that the child witness has to be scrutinized very closely, his statements. Now here what we find, the son had said in clear terms that he was present. He was present along with his sister. Sister was again younger, she was not examined. And then the son said that there was a quarrel, and quarrel used to happen every night. And there was a quarrel, and there his father assaulted his mother and strangulated. Before the trial court, he said strangulated. and her mother met death. He shouted, aunt came. In 164 will be used to corroborate or to contradict. So corroboration comes from 164. 164 of course, the child did not say about strangulation. Child said there was an assault. Father assaulted his mother. Mother fell down. Then she was lying on bed and she was found dead. And I have seen it is only after a few months that he was brought to the trial court and he was examined. It was not long before. And so, anyways, the corroboration of the child witness's statement before the trial court is there in his 164. Although not in so many words, that strangulation part was missing. But child witness, he is 8 years old, 9 years old. If we scrutinized it very closely, what we find is, yes, there was an assault. There was a marpit, there was a quarrel, followed by an assault. So that part is corroborated. So child witness, child statement is believable. I cannot say it is not believable. Coupled with the other evidence, he was there at the night. He did not explain under 313. 313, what he said is son was tutored. What happened that night? He did not say anything. So no explanation. He was present. Son has given his statement and he was absent after the death. Villagers did not find him at home. He was absent. He left. He fled. So coupled with these evidence and rest evidence is there because when the villagers went to the place of occurrence, PW1, who was the eyewitness, he stated to all that my father did this. So rest evidence, his absence, his presence at the night, his absence after the occurrence, son's evidence and no explanation. She is rightly, submitted that homicidal death in the hands of the accused is more or less proved. Now going to the conversion. Quarrel is of course there. Quarrel, in fact, there are quarrels amongst husband and wife, which is a very common feature. Here he was drunk. And to take the advantage of his being drunk, this is not possible in this case because under general exception, this intoxicating element has to be given to him forcibly without his intent, without his will, against his will. That has not taken place. He is himself drunk. And he came back. There was a quarrel. Quarrel followed by all this assault. And to invoke exception 1 will not come. There is no grave and sudden provocation. That is no evidence is there in respect of exception 1. So exception 4, there are so many ingredients in exception 4. Without any premeditation, without taking undue advantage, not in a cruel manner, in a mutual fight. Those ingredients, if your lordship wants to invoke, it will be difficult. Apart from quarrel, there is nothing. What kind of a quarrel? Who took advantage? Whether wife had also some participation?
Quarrel
Could not-
itself is a participation.
Uh-huh.
Quarrel itself is participation.
No,
When we
I
say-
mean in a mutual fight. So that has to be from both the sides.
upon a sudden quarrel. I say exception 4, a quarrel word is there. Sudden
Sudden.
quarrel. Quarrel word is
Heat of
there in
passion
exception
involved.
4.
Exception?
Exception 4, lordship
4.
is saying that the sudden, that all the ingredients are not there, but in a sudden fight, in a heat of passion, upon a sudden quarrel, and without the offenders having taken any undue advantage. There is only one, lordship. One injury in the neck.
There are bruises. Of course, bruises are not
Bruises,
explained.
doctor-
But in the inquest report, lordship will find, inquest report, it's not that there were no injuries at all. Inquest report, lordship will find it at page 36. 36, what he said is last 4 lines, lordship will see. The mouth is open, tongue is inside the mouth. There is injury on the neck. Neck is, of course, that is the fatal injury. Private parts are examined, the dead body is examined by turning it over again, and minor injuries were found present at the belly and neck. In order to ascertain so there are injuries, injury on the neck, dead body is turning, minor injuries are found on belly and neck. In order to ascertain, dead body is sent. And the doctor has said that injuries can happen, the bruises can take place when transporting to the for postmortem.
Last line.
That part is there. So the fatal injury is on the neck. But this is not a single blow or something. This is strangulation in the neck and some assault.
Asphyxia,
Asphyxia as a result of throttling.
congestion of lung.
Throttling. But the son said that he was assaulted. She was assaulted. That assault part, of course, we did not get much injuries, only on the belly. And as far as, of course, 302, 300 exception, I'll just go through once. Exception 4. Exception 4. Culpable homicide is not murder if it is committed without premeditation in a sudden fight. Exception 4 to section 300. Section, Lordship got exception 4. Culpable homicide is not murder if it is committed without premeditation in a sudden fight. Fight used to take place every day in our case. In the heat of passion, upon a sudden quarrel, and without the offender, these are all and without the offender having been taken undue advantage, or, this is all, acted in a cruel or unusual manner. This is throttling of a woman. But there are so many Supreme Court cases saying that without going into so many, all the ingredients, it is converted at times, seeing the condition. If it is a one blow, if she dies later, and in those cases, it is converted. Here is a case where only quarrel took place.
The quarrel was taking place every night.
Every night. They used to quarrel. He comes drunk.
There was provocation.
It happens. It happens. There is a Guwahati High Court case where the wife has been tortured for many years, and that was in her mind, and that accumulated, and then finally she had killed her husband.
Yeah.
That was taken to be a grave and sudden provocation.
Nanavati case, and then Ahluwalia case in England, Lordship. Ahluwalia case, she was tortured by her. That was the first case of this torture by the husband, and for a long time, and then she kills.
Series of acts. This is what Supreme Court says. Even by series of acts, it can lead to sudden and grave provocation. So here is a case, of course, he is inside since the time of his arrest. And only the injuries were on neck, throttling or strangulation. So I'll leave it to your Lordship. Lordship can convert it. Children are young, of course, 6 and 8. By now, they will be around 11, 12.
Exception 4.
Exception 4. Leave it to your Lordship. Otherwise, homicide is proved and only quarrel. Evidence is too little for invoking exception 4. But these are all tea garden laborers seeing the society, the kind of society they stay in. Otherwise, ingredients of exception 4 are not meted out.
Exception 1.
Even grave and sudden provocation can also be there. The Lordship has rightly pointed out, she was harassed every day. And then, grave and sudden provocation not in case of the wife, it is in case of the husband.
Yeah, if she keeps on fighting every day, nagging every day, Lordship, that is also a torture. If the husband, he had gone to work somewhere, 3 days before the Bihu festival, he came back. And if the wife keeps on nagging him, all the time he comes back to the home, that is, I think, Lordship, any man will be agitated.
But that is not in the evidence. It's
No,
only
quarrel
quarrel.
is there. Every witness has said quarrel.
Quarrel is there.
And quarrel, Lordship,
Quarrel
it
is
cannot,
there.
Lordship,
And, he was under the influence of liquor.
Mm,
Yes.
So in his 313 statement,
mm.
he said that he was not under the
He was not.
under the influence.
Acha, acha.
Just
That I did not find. He said that
No,
the
he
son was
denied it.
tutored.
313.
21, page 21.
It's in a liquor. He has adduced so out of anger. The deposition was false now.
The
Tutored.
last 3 lines.
Oh, acha.
Page 22.
Yes, I did not come. No, I did not come under the influence of liquor. I did not kill my wife. Yes. Even if he is under the influence, he cannot take that ground because that liquor has to be forcibly given without against his will. No, of course, only quarrel is there. Otherwise, very less evidence. And that quarrel part and all was not examined by the trial court. It was not gone into. Trial court simply relied on the son's evidence coupled with the other, his absence or not. Lordship will see the last paragraph of the trial court's order.
Very short.
This is at paragraph 21. Oh, page 30. The findings. Page 30, paragraph 21. The Lordship get. Thus, we find that as the accused was very much present with his wife in his house at that relevant time, Lordship got it. It is his burden to prove the fact that he was not responsible for her death. More so when his son, the APW1, who too was present in the house at that relevant time, has implicated him on the offense charged against him. He has no explanation in his examination under section 313 CRPC as to how his wife died. Evidence shows that PW2 and 4 did not find him in his house soon after the occurrence. PW5 had deposed that he did not find the accused on the next day morning when the dead body was brought out from the house by him at the request of the police. The evidence that emanated against the accused and his absence at his crucial time in his house after the incident, coupled with lack of any explanation on his part in this regard, established that it was he who had intentionally killed his wife. The argument of the defense that as the incident occurred in the darkness of the night and therefore the evidence of PW1 cannot be relied to convict the accused lacks soundness and is found to be not based on evidence on record. These are the findings. The credible, consistent, and inspiring evidence available on record leaves no doubt in my mind and to finally hold the accused guilty of the offense charged against him beyond reasonable doubt. The quarrel part was not gone into, it was not deliberated upon. These are a humble submission, only quarrel, if it all can be used for conversion.
But MS RD Mazumdar. Also heard yes, yeah. Additional PP. correct?
Mm.
What is it? Just
Observe. Highly obliged, sir.
to my general.
4 and 5.
Wait, your lordship. In this matter, my lord, conviction is. In this matter, my lord, conviction is based on only sole witness of the daughter of the deceased. Her parents were died in a mob lynching. They are supposed to be practicing witchcraft, and accordingly, in the tea garden area, people kill them. Only eyewitness is the 9 years daughter of the deceased persons, my lord, on the basis of which that conviction was made. But I found contradictions in the evidences 164 as well as deposition before the trial, my lord, magistrate. First, my lord, FIR at page 4 of the paper book, my lord. Humble submission is that I am a line pocketder of line number 10 of Hansara Tea Garden around 11 p.m. on 15/8/17. A person, namely Sri Gopi Means of this line, accompanied by some other persons, both male and female of the line, called Sri Dilip Kishan and his wife Srimati Sibrati Kishan from their house, which is situated at the same line, and suspecting them to be witch. They brought them across the garden and killed them on the road of the line near our house by dealing twist and kick blows and blows with lathi. Therefore, it is prayed to take necessary action upon investigating the matter. In this matter, my lord, as 13 witnesses were examined. Out of them, they have 4 witnesses of 164 also. That is already exhibited, my lord. And PW1 is the informant here, my lord. Page 12. I am the informant of this case. I know all accused of this case. They hail from the same line of our garden. I know Dilip Kishan and Sivrati Karmakar. The occurrence took place last year on 15th August 2017. At the time of occurrence, I was sleeping in my house. My family members were not present at that time. My house is also situated in the same line as of the accused. My son Vikas Mura woke me up and told me that a murder had taken place in the football field. I went out of my house and saw that 2 dead bodies were lying near my shop. I informed the garden manager. The deceased persons were murdered on the occasion of that they were exercising witchcraft. On the next day, I have lodged an ejahar before police. Exhibit 1 is the ejahar and Exhibit 1:1 is my signature thereon. Exhibit 2 is my statement recorded under Section 164 CRPC, and Exhibit 2:1 and 2:2 are my signatures. I have heard that the accused Gopi Bindia and Gautam Bindia, along with some other persons, had committed murder of the deceased persons. Police says 13 numbers of bamboo sticks which were found lying by the side of the dead bodies. Exhibit 3 is the CGI list and Exhibit 3:1 is my signature thereon. Police also conducted inquest on the dead bodies and prepared inquest reports. Exhibit 4 and 5 are the inquest reports, and 4:1 and 5:1 are my signatures. In his cross, it is only stated that the football field where the dead bodies were kept, my lord, it is situated at a distance about 2 to 3 kilometers away from his house. He did not go to the football field. PW2 at page 14, my lord. He is a garden employee. I know Debaru Mura. This is Shivrati Karmakar was my sister-in-law and this is Dilip Kishan was her husband. The occurrence took place in the last Shravan month. It took place on 15th August at night. At the time of occurrence, it was about 9:10 p.m. and I was in my house. The accused Gopi and Gautam had committed murder of Shivrati and Dilip Kishan. I came to know about the said fact only on the next morning. I noticed their dead bodies lying on the road. I also noticed several injury marks upon their persons. My house is situated at a distance of about 1 kilometer away from the house of the deceased persons. In cross, it is stated the place of occurrence was football field and it is situated at a distance of about 2 to 3 kilometers away from my house. Near the field, there are several Katsa houses. PW3 is also a garden worker, my lord. The complainant Devaru Mura is the husband of my parental aunt. He is the line chowkidar of our garden. The deceased Dilip Kishan and his wife Shivrati Karmakar were also my parental uncle and aunt. The occurrence took place on 15/8/17. It was about 9:10 p.m. and I was sleeping in my house. My wife woke me up and told me that Dilip Kishan and his wife Shivrati Karmakar were apprehended by the villagers and they were taken to the house of the line chowkidar Debaru. I went there along with my wife. When I reached there, I saw that Gopi and Gautam were beating Dilip Kishan and his wife. At that time, they were already dead, but those two persons were still beating the deceased persons. A lot of people were present there, but except Gopi and Gautam, others were just watching. I did not ask anyone as to why Gopi and Gautam were beating the deceased person as because they were possessing sharp weapons with them. As my children were in my house, so we immediately returned home. The deceased persons were killed on the occasion that they were practicing witchcraft. In cross, it is stated the accident occurred on the day when the Independence Day was celebrated. It is not a fact that I did not state before police like this. When I reached there, I saw Gopi and Gautam were beating Dilip Kishan and his wife. At that time, they were already dead, but those two persons were still beating the deceased person. A lot of people were present there, but except Gopi and Gautam, others were just watching. I did not ask anyone as to why Gopi and Gautam were beating the deceased persons was because they were possessing sharp weapons with them as my children were in my house. So I immediately returned home. The deceased persons were killed on the occasion that they were practicing witchcraft. At the relevant time of occurrence, I was sleeping in my house. The accused Gautam and Gopi informed the garden manager that two persons have killed. The actual occurrence took place in an open field. My house is situated at a distance of about 1.5 kilometers. From the field, it is not a fact that today I have deposed. It is not a fact that today I have deposed false evidence by stating that Gopi and Gautam were beating the deceased person. PW4, in his statement, it is stated he know the complainant. He is also who is a line chowkidar. Occurrence took place on 15 August last year, and his house is situated about 3 kilometers from the house of the deceased persons. The dead bodies of deceased persons were kept in front of the house of the complainant Devaru Mura. I did not go there. Police recorded my statement. I was also produced before magistrate for recording my statement under 164 CRPC, wherein I put my thumb impression. He was not crossed, my lord, it was declined. PW4 is the conducting doctor, my lord. He has done the postmortem, my lord. On 16/8/17, I was working as SDGM and HO at Tinsukia Civil Hospital. On the day about 3:15 p.m., I had conducted postmortem examination upon the dead body of Dilip Kisan. In connection with Dumduma PS GDE number 450 dated 16/8/17, the dead body was brought and identified by UBC 112 Bimal Kumar and Sri Debaru Mura and Sri Jeki Kisan. On examination, I found the following. These are the injuries, my lords, 1, 2, and 3, where lacerated injuries are right forehead and left chin, including left eye also, my lord. In opinion, my lord, said, in my opinion, the cause of death is due to shock and hemorrhage as a result of the injuries sustained, which are antemortem and homicidal in nature. Time since was 12 to 18 hours. Injury number 1 and 2 are individually sufficient to cause death of the person in normal course. Exhibit 6 is the postmortem report and Exhibit 6.1 is my signature. Along with the dead body, I also received the inquest report. Exhibit 4 is the inquest report and Exhibit 4.2, 4.3, 4.4 and 4.5 are my signatures. His cross is also declined, my lord. In a similar manner, the doctor also marked that same injuries are related to the wife also, my lord. That is Sivrati Karmakar. Injuries number lacerated, number 1 is lacerated injury on face and second one is multiple bruises over the body of that lady, my lord. In my opinion, the cause of death is due to shock and hemorrhage as a result of injuries sustained, which are antemortem and homicidal in nature. Time since date was 12 to 18 hours. Exhibit 7 is the postmortem report and Exhibit 7 1 is my signature. Along with the dead body, I also received the inquest report. Exhibit 5 is the inquest report and Exhibit 5.2, 5.3, 5.4, 5.5 are my signatures. Page 20, PW6. He happened to be the son of the deceased, my lord. I know the complainant Debaru Mura. He is the line worker of the garden. The deceased were my parents. I know all the deceased accused of this case. The occurrence took place on 15/8/17 at night. I reside at Doidam TE, whereas my parents used to reside in Hansara TE. It takes half an hour to travel between two houses in a bicycle. On the next day of occurrence in the morning, I went to the office of Hansara TE. My friends told me that my parents were murdered in the previous night. I was told that the accused of this case has committed murder on my parents. They killed my parents on an occasion that my parents were practicing witchcraft. My sister Susma Kisan was residing with my parents at the time of occurrence. She was about 10 years old at that time. One Bulu was also residing with my parents at the time of occurrence. Bulu is the daughter of the elder brother of my mother. In the police station, all the accused persons had admitted that they had committed murder on my parents. I have also asked my sister Susma as to how the occurrence took place, and she told me that accused had come to the house and dragged out my parents and also beat them. My sister told me that my parents were taken to line number 10 and killed them there. Police conducted inquest on the dead bodies of my parents and prepared inquest reports. 4656 are my signatures. Police had since bunch of bamboo sticks. Exhibit 3 is the seizure list and Exhibit 3(2) is my signature thereon. The offense of Hansara T is situated as distance at about 16 kilometers from my house. Similarly, the house of my parents is situated at a distance of 5-6 kilometers from the office of the Hansara TA. After hearing about the death of my parents, I had gone to section number 14 of the garden to bring one machine. After that, I had gone to the house of my parents. At that time, police was present there. Along with police, I went to the police station. It is true that I did not state before police that I had heard from my parents that the accused of friends that the accused had committed murder of my parents of the previous night. It is not a fact that I did not state before police like this. This is his, these are the suggestions, my lord, repeating the same thing here. It is not a fact, next para, my lord. It is not a fact that I have deposed false evidence by stating that I have asked my sister Susma as to how on occurrence took place, and she told me that accused had come to the house and dragged out my parents and beat them, and my sister also told me my parents were taken to the line number 10 and killed them there. It is not a fact that I deposed false evidence by stating that the accused had committed murder of my parents. In his evidence, my lord, though he is repeatedly stating that his sister is informed him about the incident and he has told how it was, she has told how it was happened. But while we go through that his sister's version, my lord, there is a contradiction. She has nothing expressed anything before her brother, my lord, regarding the incident, my lord. PW7 is one of the daily wage earner, my lord. He stated, I know complainant Debaru Mura, he is the chowkidar of the garden. I know that this is Dilip Kisan and Sivrati Karmakar. Their house is situated at distance about 2 kilometers from my house. The occurrence took place 15/8/17 at night. At that time, I was in my house. I know all the accused of this case. Gopi Binzia come to my house on that day and told me that they had apprehended witches and killed them. He asked me to come to the place of occurrence, and accordingly, I went there and I saw the dead bodies of both the deceased persons. Police sent me to the court for recording my statement 164 CRPC. Accordingly, I gave statement and put my thumb impression therein. In cross, it is stated, when Gopi come to my house, it was about 10 p.m. I do not know where the occurrence took place. I do not know who killed the deceased persons. Police instructed me as to what I should state. When I was sent to the court for recording my statement. So what he has stated before 164 and here, my lord, it is tutored as per cross, my lord. I have the statement as per the version of police. Next one is PW8, my lord. He is also a garden employee, and ultimately his version was declared hostile, my lord. I know complainant Devaru Mura, who is the line chowkidar of our line. I know deceased persons, namely Dilip Kisan and Sivrati Karmakar. I know all the accused, including Gautam and Gopi Binzia. I do not remember the date when the occurrence took place. The occurrence took place at night. The deceased persons also lived in my locality. At the time of occurrence, I was sleeping in my house. Next morning, I come to know that the dead bodies of the deceased persons were lying in front of the house of Devaru Mura, the line chowkidar. I went there and saw the dead bodies. In cross by prosecution, it is stated, it is true that when I gave statement to police, I had stated in the night stated that in the night of the day of occurrence, while I was sleeping in my house, Gopi had come to our house, and at the time he was holding a dove in his hands. I also stated before police that at that time Gopi was asking us to come with him in order to kill a witch which they had captured earlier. I also stated before police that my wife did not allow me to go with Gopi, and therefore Gopi had left our house. It is not a fact that I have deposed false evidence in order to save the accused from being punished. In defense crossed, it is stated that deceased persons resided in a separate line, not in our line. I did not meet police. I do not know how I have been made a witness in this case. In the night of the occurrence, I was sleeping in my house and woke up in the morning only. PW 9. I know the complainant, Devaru Mura, line chowkidar of our line. I knew the deceased Dilip Kishan and Roti Karmakar. I also know all the accused persons. The occurrence took place in the month of August last year at night. I do not remember the date of occurrence. It took place at night, and the distance between my house and the deceased would be about 150 feet. 150 feet. At that time of occurrence, I was sleeping in my house. Somebody was shouting at us at midnight. I woke up and went out of the house, but I could not find anyone outside my house. Next morning, Gopi Bindia came to our house and called us to come to the house of Devaru Mura. Accordingly, I went there and saw the dead bodies of Dilip Kisan and Sivrati Karmakar, which were lying in front of the house Devaru Mura. Police did not record my statement. Her cross is also declined, my lord. PW 10 and 11 are newspaper reporters, my lord, and they for the purpose of reporting, they videograph the that accused person's versions, my lord. I do not know complainant Devaru Mura, PW 10, page 27. I do not know complainant Devaru Mura, nor do I know the deceased Dilip Kishan and Sivratri Karmakar. I do not know any one of the accused of this case. The occurrence took place last year. I do not remember the date. On the next day of the day of the occurrence, I come to know about it. I come to know that on an occasion of, the spelling is wrong, my lord, of practicing witchcraft, two persons were murdered in Hansara TE. For reporting the matter in television, I went there along with Ajoy Thakur about 10:30 p.m. I reached the place of occurrence. I saw the dead bodies lying on the ground, and I also saw that policemen were already present there. We took the footage. I interviewed one person. He spoke something about the incident, but I do not remember now what he said. I gave one copy of the DVD containing the said interview to the police. Police says the DVD, Exhibit 8 is the said seizure list. Exhibit 8.1 is my signature. Same person is mentioned as per deposition of PW 11, my lord. He is also happened to be a newspaper reporter, my lord. I do not know the complainant Devaru Mura, nor do I know the deceased Dilip Kisan and Sivrati Karmakar. I do not know any of the accused of this case. The occurrence took place in the month of August 2017. I came to know that on the occasion of practicing witchcraft, two persons were murdered at Hansara TE. I, along with Sujit Dev, went there. We video footage of the two dead bodies. It took over. When we reached there, policemen were already present there. I recorded one interview taken by Sujit Dev. The four persons were persons who gave the interview to Sujit Dev was telling that since the accused were practicing witchcraft, it has to be deceased, my lord, not accused. They had killed them. I did not know the name of the person who spoke like that. A copy of video containing the said interview was given to the police. Police says the same, and that is the exhibit A, and 8-2 is his signature. In cross, it is stated the villagers of the village where the deceased person resided were involved in the said murder. PW 12 is the daughter of the deceased, my lord. On the basis of her evidence, that conviction was there, my lord. Susma Kisan, her age is 9 years.
Eyewitness.
Eyewitness. She happened to be the eyewitness as projected, my lord. First 5 questions are preliminary questions, my lord, to justify her understandings, my lord. I'm starting from my mother's name was Sivrati, and question number 3 is important, my lord. Where do you stay? I stay with my elder brother J.K. Kisan at Doinam TE. Where your parents are, they were killed. Where do you reside when your parents were killed? At line number 10 of Hansara TE. It is along with her parents, my lord, on the day of occurrence. I hereby certify that witness understand the question and put us able to give reasonable answers. On oath, my mother's name was Sivrati and father's name was Dilip Kisan. I know the accused Gopi. I also know the accused Bottom Elias Gautam. More than 1 year ago, the occurrence took place. The occurrence took place at about 10:11 p.m. At that time, we were sleeping after having food. At that time, Gautam, Gopi, and some other persons from our line had come to our house and asked my mother from outside to open the door of the house. When my mother was opening the door, I was behind her. When my mother came out of the house, Gopi and Gautam had some other persons hit my mother with the blunt side of the dao. At that time, my father came out from his room. Then Gopi, Gautam, and the other people gave blows to my father with blunt side of daws. They also used stick to beat my father. Thereafter, my mother and father were dragged to the house of Line Chokidar Debaru Mura. Thereafter, some people dragged me to the house of Debaru Mura and I was asked to stand there. Thereafter, the people from the line along with Gopi and Gautam were assaulting my parents. I had seen the incident with my own eyes. And it took place in front of me. My parents died because of the said assault. Police brought me to the court for recording my statement under 164. Exhibit 9 is my statement. 9192 are my signatures thereon. We have electricity connection in our house. I saw the accused in the light of electricity bulb. Today, the other persons, namely, all these are named co-accused, my lord, were also present at the time of occurrence. They also participated in the occurrence. As per judgment, my lord, there is no such evidence leading against the co-accused. They were given acquittal, my lord. Only the Gopi and Gautam, they were convicted, my lord. The distance between my house of that Debaru Mura, in cross it is stated, the distance between my house and Debaru Mura will be at about 1 kilometer. The entire incident took place in front of the house of the Debaru Mura. When police came to our village, I was in the house of Debaru Mura. Police came at about 10 a.m. in the morning. On the day of occurrence, the people from our line took me to the house of Debaru Mura. On the day of occurrence, Bulu, the brother of my uncle, was also staying in our house. She was also sleeping with me. Probably it's a daughter, my lord. She was also sleeping with me on the night of occurrence in our house. There is a field in our village which is about 1 kilometer from our house. My father married twice, and Jackie Kishan is my brother from the first wife of my father. On the day of occurrence, during the daytime, in the morning hours, Jackie Kishan had come to our house. He resides at Doinam, TA. I do not know the name of the mother of the Bulu, though she is my maternal aunt. When went to the police station, I was accompanied by my maternal aunt and other people. But in the police station, I met my brother Jackie Kishan. While we were in the police station, my maternal aunt asked me not to talk to Jackie Kishan. Accordingly, I did not talk to my brother Jackie Kishan. I repeatedly tried to come near my brother, but my maternal aunt held me back. My maternal aunt tutored me as to how I should give statement to police. While my statement was being recorded by police, my maternal aunt was by my side, and police also recorded the version of my maternal aunt while they were recording my statement. My maternal aunt, that is the mother of Bulu, brought me to the court while I was sent there for recording my statement under 164 CRPC. After 2 days of the incident, my statement was recorded in the court. On these 2 days, I stayed in the house of my maternal aunt. On both those days, my maternal aunt taught me what to speak in the court. As per tutoring given to me by my maternal aunt, I gave my statement under section 164 CRPC. I like to play Ludo. The accused who are present in the court today belong to my village, and I do not know their names. I do not know the names of the parents of the accused Gautam. Today I have been brought to the court by my brother Jackie Kishan and his wife Karisma Kishan. They told me to give evidence properly. They explained to me about the facts of the case and asked me to speak properly in the court. On the night of the occurrence, Bulu was also taken to the house of the Devarumura. There is no electricity line in the house of Devarumura. In the open field also, there is no electricity light. I do not know the house of Julumura and Lengi Karmokar, Gopi Bindia, Babul Mangil Mura, Monju, Konumura, etc. There are 300, 400 people in the village. All of them came to take me to the house of Devarumura on the day of occurrence. When I was taken to the house of Devarumura, at that time, Bulu and myself were present in our house. When I reached the house of Devarumura, I saw that the police were assaulting people were assaulting my parents. Many of the people were assaulting my parents. Where my parents were assaulted, that place was lit by electricity light. There is a tube well in front of the house of Devarumura. I had stated before police that when I arrived at the place of occurrence, I saw that my parents were lying dead near the tube well. It is not a fact that I did not state before the police that at the time of Gautam, Gopi and some other parents from our line had come to our house and asked my mother from outside to open the door of the house. When my mother was opening the door, I was behind her. When my mother came out of the house, Gopi and Gautam and some other persons hit my mother with the blunt side of the dao. At that time, my father came out from his room. Then Gopi, Gautam, and the other people gave blows to my father with blunt side of the dao. They also used sticks to beat my father. This version of the eyewitness, my lord, doesn't completely tally with the version of 164, my lord, as though she is being presented by the prosecution as an eyewitness, but all along in cross, it is very clear that her maternal uncle all along stayed with her from the date of incident till reporting the 164, recording the 164, as well as this evidence time also, giving this evidence also, that she was all along tutoring, my lord. And what she has to speak before court, it was already been taught by her maternal aunt, who accompanied her till the police station as well as the court also, my lord. PW 13 is an investigating officer, my lord. On 16/8/17, I was working at Dumduma PS. On that day, Sri Pritam Sharma, assistant manager of riding TS, verbally informed the police station that on a suspicious of practicing witchcraft, a husband-wife couple were murdered and their dead bodies were lying in the line number 10 of the garden. On the basis of the said information, a ZD entry on 150 dated 16/1/18 was made by OC Mani Mohan Post. Exhibit 10 is the certified extract copy of the said GD entry. I was entrusted the task of investigation of the case, so I immediately went to the place of occurrence. I reached the place of occurrence at 7:30 a.m. I prepared the sketch map of the place of occurrence. Exhibit 11 is the sketch map. 11:1 is his signature. He conducted inquest upon the dead bodies, which is this is persons, my lord. That is exhibit number 4 and 5, and respectively their signatures were also put. I recorded statements of Debaru Mura, Dekhi Kisan, Lengi Karmakar, Pratap Karmakar, Susma Kisan, Ravi Mura, Vijay Heria, Monu Gaur, Vijay Gaur, and Priyam Sharma. At that time, I seized 13 numbers of bamboo stick, which was suspected to be used for commission of the offense. Those sticks were lying scattered at the place of occurrence. Exhibit 3 is the seizure list. Exhibit 3.3 is my signature. I sent the dead bodies for post-mortem examination. I arrested 31 numbers of accused on that day itself. I recorded their statements. On the day at about 12:05 p.m., the written Ejahar was lost by the Debaru Mura. On the basis of the said Ejahar, OC registered the case as Dumduma PS case number 239/17 under section 143, 109, 120B and 302 IPC. Exhibit 1 is the Ejahar. Exhibit 1.1 is the signature of Mani Mohan Kos along with endorsement. I am acquainted with the signature of Mani Mohan Kos and I was entrusted the task of investigation of the case. When I was in the place of occurrence, some media persons were also present, and before them, the accused admitted that they had committed murder of the couple as because they were practicing witchcraft. Thereafter, I had seized the DVD containing those statements. Exhibit 8 is a seizure list to that effect. 8.3 is my signature. Thereafter, on conclusion of investigation, I collected the postmortem report and filed the charge sheet against the accused. Exhibit 12 is the charge sheet and Exhibit 12.1 is my signature. The occurrence of this case that is in cross, the occurrence of this case that is assault upon deceased person took place in a playground. Debaru and Susma told me like that. This playground is situated in front of the house of the deceased persons. None of the witnesses whom I have examined have claimed to have seen the occurrence on the playground. The incident occurred about 9:10 p.m. on 15/8/17. PW 12, Susma Kishan was in custody of Lengi Karmakar after the night of the occurrence. Susma was 8-9 years old. I did not test Susma as to whether she was tutored or ascertain the authenticity of her statement. There is nothing in the CD to explain as to why Sushma was not sent to the court on 16/8/17 and 17/8/17, as her deposition 164 was taken after the 2 days of the occurrence, my lord. She was sent to the court on 18/8/17. There is nothing in the CD to show as to in which custody Sushma was there during those 2 days. Though I sent the victim girl to the court on 18/8/17, the court recorded her statement on 24/8/17. That is much later, my lord. I had collected the copy of the statement of Sushma recorded under section 164 CRPC. At the time of filing of the charge sheet, I had taken into consideration the statement of Sushma. The witness Sushma PW 12 in exhibit 9 did not state the accused person assaulted her person with dowel and sticks. Here is the contradiction, my lord. I will, Lordship may produce the 164 statement also. It is corroborated by that evidence, my lord, that he did not speak about that, she did not speak about that accused person's assaultment, my lord. The witness Sushma did not state before me that Gautam, Gopi and some other persons had come to her house and asked her mother to open the door. And when her mother opened the door, she was behind her. The witness also did not state before me that when her mother had come out of the house, Gopi, Gautam and some other person had hit her mother with the blunt side of the dowel. She also did not state before me that when her father came out of the room, Gopi, Gautam and other gave blows to the father with the blunt side of the dowel. The witness also did not state before me that miscreants used sticks to beat her father. When I first reached by the side of the incident with her own eyes. During cross-examination, that part of the evidence has not been challenged. In paragraph 31, my lord, while this reasoning was recorded, my lord, there is no such mention about the tutoring part of the eyewitness, my lord. Sushma Kishan, no doubt prudence of demand that evidence of a child witness must be evaluated carefully and with greater circumspect because of child witness is susceptible to the swayed by what others tell him and he is an easy prey to tutoring. However, that does not mean that court has no meaning with the presumption that child witness is untruthful or unreliable. Here one judgment is quoted by the learned below where the tutoring part is there, but so far as this so far as reliance is placed, my lord, there is no such mention about the tutoring part. So placing upon reliance of this judgment is not correct, my lord. Para 37, my lord, in page 89, last para, my lord. In my considered opinion, the evidence of Sushma Kishan has inspired confidence to the effect that it was Gopi Bindia and Gautam Bindia who had taken part in the incident that caused death to Dilip Kishan and Shivrati Karmakar. Her evidence that two accused had beaten her parents to death in front of her eyes has not been challenged during her cross-examination. Under the circumstance, I find that the offense of murder of Dilip Kishan and Shivrati Karmakar is proved beyond all reasonable doubt against the accused Gopi Bindia and Gautam Bindia only. The evidence, however, failed to prove the offense against the other accused. Accordingly, my lord, they were sentenced to life and other were with a fine of 25 rupees, rigorous, failed to rigorous imprisonment. There is another 6 months, my lord. So far as the contradiction of 164 are concerned, my lord, kindly peruse. Page 128, my lord, that is exhibit 8. While this video recording was by this schedule is that video recording of the reporters was said, but it was never placed before the court. Neither any prosecution has relied on those evidences, my lord. Where one statement is made by the prosecution witness, that reporter, that the assault part is admitted by one of the accused person, my lord.
Page.
Page 123, my lord. Description of seizure, my lord, heading is there. One DVD or Sony so-and-so where contained video of interaction of accused Sri Gopi Bindia with media person. During interaction with media person, the accused Gopi Bindia confessed that he, along with some other people of Hansara 10 number line, had killed the witches Dilip Kishan and Shivarati Karmakar. Those evidence was never placed before the court as depicted from the deposition of investigating officer, though it was, he clearly stated in cross that it was, though it was seized, but no such was, that DVD was never played and no prosecution witness has never, no, prosecution has not present before it court, my lord, as a matter of evidence. Next one is 125, my lord. That 164 statement of so-called eyewitness, my lord. Relevant page is 126, the next page, my lord. On 15/8/2017, I was sleeping at my house along with my parents, Sivrati Kishan and Dilip Kishan. Suddenly at about 9:10 p.m., Gopi Bindia and Bottom Bindia started knocking at the door of our house. My mother opened the door. Hearing the sound of knocking, I also woke up. Then Gopi entered our house and slapped my mother. Bottom then caught hold of the hand of my mother and dragged her away. My father then went out and Gopi caught hold of him and took him away. I saw that Gopi was holding Daloi. And it's a Daloi is a weapon, my lord, where the tea garden laborers using that weapon, that instrument for cutting the tea bushes, my lord. It's more or less like dao, my lord. And Bottom was holding bamboo lathi. I was very scared and remained at my house. In 1/6 all along, she said in deposition before the trial court, my lord, that all along that murder was before incident took place before her eyes, my lord. But here he said that upon being entered those accused persons to her house, she was very scared and she remained in her at her house. Then after some time, Gopi and Bottom came to my house again and asked me to go with them. I was frightened and I saw and so I followed them. They took me near the house of the line chowkidar, and there I saw my father and my mother were lying on the ground. I saw that the left eye of my mother had been scraped out, and there were abrasion marks on the posture of my father. Gopi and Bottom then told me that they had killed my parents as they were witches. Many people had gathered at the place, but I do not know their names. I then went to the house of Negri, who resides near the house of our line chowkidar. Gopi and Bottom reside near the house. I have known them since long. In this evidence 164, she never expressed that happening was before her eye, in front of her eyes, my lord. And next one is 133, that is 164 of Robi Mura, my lord. My name and address given above are incorrect. My age is 32 years, reside in the line of 10 number Ansara Bagan. On 15/8/17 at about 9 p.m., I was sleeping inside my house along with my wife Srimati Falko Mora and 3 children. At the time of Gopi Bindia and Bottom Bindia started knocking at the entrance door of my house, and they also called me. I woke up and opened the door and saw that both Gopi and Bottom are holding down an axe. They told me that they were going to catch one witch and asked me to go with them. I followed them, and when we reached near the house of our line chowkidar Devaru Mura, I saw that the dead bodies of Sivrati Kishan and Dilip Kishan were lying near the house. At that time, my wife Falko Devaru Mura, wife Devaru Mura Bongi, Konda, Langri, and some other people were also present, but I cannot remember their names now. We all asked Gopi and Bottom as to why they had killed Sivrati and Dilip, to which Gopi told that he had killed Sivrati because she was a witch. I also saw that the Dao and Gopi was soaked in blood. Both Sivrati and Dilip had injuries all their body and head. Someone had informed the police. I and my wife thereafter returned home. In this evidence, my lord, he tried to convey, he asserts that Dilip, they have Gopi was holding a dove soaked in blood. But that sustained weapon was, although dove was seized, but no such forensic evidence led to the extent that regarding the report on blood soaking, my lord, and it was never produced before the court below. So far as another was 135, 164, that is Bijoy Korea, my lord. My name and address given are correct. My age is 26 years. I reside in the line number 10 Ansara Bagan. On 15/8/17 at about 10 p.m. I was sleeping inside my house. At that time, Gopi Vindhya and Bottom Vindhya started knocking at the entrance door of my house, and they also called me. I woke up and opened the door and saw that both Gopi and Bottom were holding down and bamboo lathi, and there were bloodstains on the same. They told me to go them or else they threatened to kill me. I followed them, and when we reached near the house of our line Chokidar Debaru Mura, I saw that the dead bodies of Shivrati Kishan and Dilip Kishan were lying near the house. I then asked Gopi as to why he had killed Shivrati and Dilip. Gopi told me that he had killed both of them as Shivrati was a witch. I saw that Dilip Kishan's forehead was cracked open and there was a deep cut mark on the left hand and abdomen of Shivrati. At that time, because who is the son of our line Chokidar Devaru Mura and Budhu were also present. Someone had informed the police. I then returned home. That blood soaking part and blood stain on the weapon, my lord, that has been used as per prosecution witnesses. It was never produced before court, and no such report regarding to that it was done by these accused persons, my lord. So far as my submission is that, my lord, so far as that eyewitness is concerned, though due to her tender age, it cannot be discussed, and but at the same time, in her cross-examination, it is very much admitted that all that she has deposed before the trial court is tutoring by her maternal aunt, my lord. And to that extent, no examination was done, neither any proof was presented before that. It was not done on her part, my lord. Now, on that count, my lord, C's conviction is in judgment also. There is no such reasoning regarding that tutoring part. And on the basis of her evidence in chief, learned court below had given convicted both the persons, my lord, accused persons. So on that count, I'd like to submit, my lord, though it is completely tutored judgment, tutored evidence on her part. So that sole witness part, sole evidence of eyewitness, so-called eyewitness of 13, that cannot be accepted, my lord, and that conviction cannot be granted on the basis of her sole witness, my lord. And secondly, she is a related witness, interested witness, as her parents had succumbed to death, my lord. To that extent, though prosecution tried to lead the evidence by corroboration of PW4 and Jackie Kishan, my lord, those who she expressed the incident, happening of the incident, but it is very much clear from the evidences that those persons, his brother was never told anything by the so-called witness, my lord, eyewitness. So in that count, there is no such corroboration, as law is very much settled. If interest is saying something, my lord, in completing the chain of circumstantial evidence, my lord, then it has to be corroborated by the independent witness also. And there is no such witness corroboration in the line of eyewitness, my lord. So I pray for in this matter that the prosecution case is not proved beyond reasonable doubt, and that learned court below's judgment has to be set aside, my lord. And I am praying for acquittal of both the persons, as no such relation is, though medical witness is there, but it is not proved that these are the persons who have done that injurious assault on the basis of which that conviction can be granted. Okay.
Lordship, I mean, I don't know 5 lordship.
The similar matter only.
Both
Yes,
the
From the same.
both the appellants are brothers, lordship.
I am appearing for Gautam India, my lord. My
I am
friend is for
Gopi
Gopi
for
India. Both accused same case.
lordship. As my learned friend has pointed out already the deposition of the witnesses, lordship. Lordship, apart from 2 witnesses, PW4 and PW12, there is no eyewitness, lordship. And PW4's evidence has been discarded by the trial court, being manifested with lordship serious contradiction, lordship. And so far as PW12 is concerned, my learned friend has rightly pointed out that her evidence has been, in my humble submission, has been demolished by cross, lordship. She admitted that she was tutored by her maternal aunt, lordship, and at the time of giving statement to police. And at the time of giving statement before the court under section 164 CRPC, she was also tutored by her maternal aunt as to what to speak and what not to speak, lordship. And at the time of lordship giving a deposition before the planet court during trial, lordship, she was accompanied by her brother, lordship, who taught her what to speak, taught her about the facts of the case. But in 164, lordship, she stated that she was at the house and she did not go, being frightened, lordship. And thereafter, Gopi and Gautam tried to take her away. And when she arrived at the place of occurrence, she only saw the dead bodies of the parents, lordship. This is person, lordship. But in the deposition before trial court, she told that she has seen everything by her own eyes, lordship. Everything happened before her own eyes, lordship. So, lordship, this corroboration has to be there as far as 164 and deposition before the court, lordship. So, I lordship, in my humble submission, her evidence cannot be relied upon, lordship, in view of the contradiction between 164 and the deposition before the trial court, lordship. And PW4, lordship, already has been discarded by learned trial court. Other witnesses, lordship, they do not lead any credible version, lordship. As a learned trial court also, lordship, observed that most of the evidence are hearsay. Most of the witnesses are hearsay witness, lordship. So, lordship, the evidence of IO, lordship, PW13 assumes significance, lordship, because he admitted in cross that this PW12, the daughter of the deceased persons, did not state before him anything, lordship, regarding that her account, lordship, what she has seen. So, lordship, in my humble submission, the credibility of this PW12 is highly in doubt, lordship. And lordship, when 30 or 31 accused are there, lordship, 29 have been acquitted, 28 on benefit of doubt, lordship. But lordship, against these 2 accused persons, lordship, only name is there, no specific role is there, lordship. So, in my humble submission, lordship, this trial court judgment rendered by the land trial court convicting both these appellants should be, lordship, interfered with, lordship. And I am praying for acquittal, lordship. That's my submission. Apply.
No, one thing that I have noticed, of course, subject to correction, the 313 consists of only one question.
3 questions.
Only
One question.
one question, that is with regard to PW12 statement, the daughter. Now, the law is that all incriminating materials has to be placed, has to be questioned, put to the accused. Here, there are other incriminating materials, like even if we discard PW3, it is said that he contradicted. But there are statements of PW6 who said that a sister said accused had dragged out the parents. PW7 statement is there. Gopi told that they caught the witches and told him to go to the PO. PW8 has stated, PW8 who had turned hostile, he had also given few positive statements against both the accused. Yes, and PW8 had also said that Gopi came with her dove to his place. PW9 also had said, morning Gopi came called to Debaru's house, saw dead bodies with weapons. So these incriminating materials has to be put to the accused. Those were not put. Only PW12 statement was put. Of course, the law is like, it has to create cause prejudice. And I remember one judgment, Nursing, 2015, 1 SCC, their Supreme Court said, even if the other party do not point out, if it is apparent by the court, if the court sees, then it will vitiate the conviction. And the requirement is that the matter has to be remanded. This is what 2015 1 SCC says. I think in my humble submission, these questions had to be put to the accused. They have not taken that point. But the other incriminating materials, even 164 statement, those are incriminating, those were not placed. Lordship, we can just see that decision once 2015 1 SCC 496. I can mail it otherwise. This is Nursing versus State of Haryana. 2015 1 SCC 496.
496.
496. I can mail it if they want.
Printer is not working. Oh,
Mail koi.
printer is not working.
Oh, printer is not working. Oh.
Anyway, just give us the relevant paragraph.
2015 1 SCC 496. I'll read out slowly paragraph 27. Paragraph 27. And it is said to what extent 30, Lordship knows 313, every incriminating materials has to be placed. This is there in paragraph 20. The question whether a trial is vitiated or not depends upon the degree of the error, and the accused must show that non-compliance with 313 Code of Criminal Procedure has materially prejudiced him or is likely to cause prejudice to him. Merely because of defective questioning under 313, it cannot be inferred that any prejudice has been caused, even assuming that some incriminating materials in the prosecution case has been left out. So they have to show what prejudice is caused to them. When prejudice of the accused is alleged, it has to be shown that accused has suffered some disability or detriment in relation to the safeguard given to him under 313 of the CRPC. Such prejudice should also demonstrate that it has occasioned failure of justice. The burden is upon the accused to prove that prejudice has been caused to him in the facts and circumstances of the case. Such prejudice may be implicit. After that, it is said, such prejudice may be implicit and the court may draw an inference of such prejudice, even if they do not show. Facts of each case has to be examined to determine whether actually any prejudice has been caused and the appellant due to omission of such incriminating materials being put to the accused. Even if it is apparent, that can be done. And 27, paragraph 27, it is said, the remedy is remanding. The point that then arising for our consideration is if all relevant questions were not put to the accused by the trial court as mandated under 313, and where the accused has also shown that prejudice has been caused to him, or where prejudice is implicit, even if they do not show, implicit, whether the appellate court is having the power to remand the case for redecision from the stage of recording of statement under 313 of Criminal Procedure Code. 386 of CRPC deals with power of the appellate court. Subsection B1 of 386 of the CRPC, the appellate court is having power to order retrial of the case by a court of competent jurisdiction subordinate to such appellate court. Hence, if all the relevant questions were not put to the accused by the trial court, and when the accused has shown that prejudice was caused to him, the appellate court is having power to remand the case to examine the accused, again under 313 of the CRPC, and may direct remanding the case again from retrial of the case from that stage of recording of the statement of 313, and the same cannot be said to be amounting to fulfilling of lacuna in the prosecution case. So here is a case what my humble submission is, all questions were not put to him. And it is apparent. And the remedy will be remanding from the stage of 313. This is one of my submission. And then regarding the merit of the case, of course, the daughter's evidence is there. Tutoring part, Lordship will see paragraph 20 and 27 of that judgment. Tutoring part, the daughter said that 164 statement was tutored, whatever her mother had said. But during the trial court, Kishan took him. PW6 took him. And PW6 said that say properly. He did not tutor. He said this, say that. He did not say that. You are going to depose whatever you state it properly. So that will not amount to any tutoring. As far as her statement before the trial court is concerned. 164 at best, it can be used for corroboration contradiction. But her trial court statement stays. As far the contradiction is concerned, in many cases, what I have found is police says that she didn't say. But while going through the case record, we normally find that she says. So if I may be allowed just to see the the statement of the daughter before the police. If I can get the LCR, I can see that statement before the police. If at all her statement was not there, then it will amount to contradiction. She cannot be believed. Then we will have to go to other evidence. I'll just read out once her police statement. The naam to kya hai? Shushma. Shushma's 161 statement. Shushma's 161. Let's see whether she had said anything. It is in English. I can read out. Debaru, JK. Oh, it's in Assamese. The statements are in Assamese. This is Shushma Kishan. Iman de moi ahisilu olop homoyar pasate amar ghoror duarot kunuba manhue dhokiai asile. She said that someone was knocking at our door. Tetia mor ma Shivaratri Kormakar uthi ahe huar pora. Her mother woke up and duar khuli diye, and she opened the door. Moyo mar logote ahu. She also came along with her mother. Ami duar khuli dekhu je amar lainot dukan thoka Gupi dada aru teor bhayek Gautam mama amar ghorle ahise. While after opening the door, they found both these brothers on the door. They have come to meet them. Dadae teor mobile to jolai eta hatot loi ase aru ankhon hatot teor da ekhon ase. He was holding a mobile phone in one of his hand and one machete in the other. Gautam mamae hatot lathi edal loi asil. The other one was holding a stick. Tar pisot Gopiye mor mak marpit kore. So Gopi had assaulted her mother. Tetia moi siori diu aru mor deuta uthi ahe. Then she shouted and her father came out. Mor mak Gautam marpit kori usorate thoka field dole tani niye. Then Gautam had dragged her mother to a nearby field. Moi bhoyote ghoror duar kakhot lukai thaku. Aru duaror fakedi sai thaku. She was peeping through the door. Tar pisot Gopiye mor deutak marpit kori mukhi goralot pelai diye. Aru deutak susorai field dole tani niye. Then they caught the father and took the father to the same field. Moi ghorot bhoyote kandi thaku. She was crying inside her home. Hihote daini dhorilu buli sior bakhor kore. They shouted that they had caught the witches. Olop homoyar pisat amar ghorle Gopi dada aru Gautam mama punor ahe aru muk dhori amar lainor chokidar ghorle loi jay. After some time, both of them came and took her to the Chokidar's house. Moi line Chokidarar naam to chini pao. Matune naam to chini pao jodiu teor pora বুলি জানো লগতো সিহঁতৰ ঘৰত দোকান আছে আচ্ছা চকীদাৰ has a house she was there মই যেতিয়া লাইন চকীদাৰ ঘৰৰ ওচৰ পাওঁগৈ তেতিয়া দেখো যে তাত বহুত মানুহ গৈ গোট খাই আছে আৰু টিউবৱেলৰ ওচৰত মোৰ মা দেউতাক পৰি থকা দেখা পাওঁ then she saw her father and mother lying injured near the tubewell so these statements police said she did not say anything of this sort but the opening of the door they dragging her mother and father to the field again taking her after some time and then she saw the bodies lying injured from the house of the chowkidar these statements are there although police in their statement had said that she did not say this is not evident this is not correct this is an incorrect Lordship. I'll just read out the PW10 statement once PW13 PW13 said Shushma did not state that the accused person assaulted her parents with dowel and sticks. This is at page 36. Page 36. Lordship will go to the second paragraph. Shushma did not state that the accused person assaulted her parents with dowel and sticks. Shushma did not state before me that Gautam, Guppy and some other person had come to her house, she had said, and asked her mother to open the door, and when her mother opened the door, she was behind her. All these things were there. The witness also did not state before me that when her mother had come out of the house, Gopi, Gautam and some other person hit her mother with the blunt side of the dowel. She did not state before me that when her mother came out, the others gave blows to father with blunt side of the dowel is not there, but assaulting is there. In her 161 statement, witness also did not state before me that the miscreants used sticks. She said on one had sticks. So this contradiction is not correct. There was no contradiction. She stated and she repeated the same statements before the trial court. So her statement coupled with, of course, she was 9 years old. One of the judgments, Supreme Court said that if some prudence requires some corroboration from other evidences. So other evidences were there because PW6, he said that sister was, when he came, sister told him that the accused has dragged their parents. That is there, corroborating her statement. PW7 said Gopi told that they caught witches and killed them, told him to go to the police station. Those statements are there. PW8 also had said, PW8, Lordship will see, although he had turned hostile, but there are positive statements. PW8 is at page 23. After he was declared hostile, he said, the last line, it is true that when I gave statement to police, I had stated, it is true that I gave statement, I had stated that in the night of occurrence, while I was sleeping in my house, Gopi had come to our house, and at that time, he was holding a dowel in his hands. I also stated before the police that at that time, Gopi was asking us to come with him in order to kill a witch while they had captured which they had captured earlier. I also stated before police that my wife did not allow me to go with Gopi and therefore Gopi had left her house. So these statements are direct statements. Those are there corroborating the statement of PW9. And PW9 also, Lordship will see PW9 said Gopi came, told to call to our Debaru's house to see the bodies. Lordship will see 5 lines from the top. I was sleeping in my house. Somebody was shouting at us at midnight. I woke up and went out of the house, but I could not find anyone outside my house. Next morning, Gopi Bindia came to our house and called us to come to the house of Debaru. Accordingly, I went there and saw the dead bodies of Kishan and Sivaratri Karmakar, which were lying in front of the house of the Debaru. These statements are there. Gopi came and called them. To PW7, Gopi told that he caught it, he killed. So PW9 statement coupled with this corroboration, the prosecution case is well meted out. And regarding the 313, I have already placed all the incriminating materials are not placed. Lordship can order.
313 is the issue.
Lordship can order for retrial from the stage of 313. This is not a very old case. This is 2018.
19.
19,
19 of convictions.
19, the conviction order was passed.
Okay.
Please, I'm a humble sir.
MS M. Burma, then it's amicus in criminal appeal jail 36.
Okay.
And Mr. N. Hassan, then it is in criminal appeal jail 37. Also heard as Jahan and addition for this stage. Can you conclude it? Just one minute. Yes, you can write.
Lordship has reserved the judgment.
Yes.
Obliged.
Obliged.
Other cases, I don't know whether we can come back.
Lordship, item number 6 and 7, my lord.
Mm.
Both all the counsels are available now, your lordship. Item number 6, your lordship, there was direction to provide lordship certain documents, my lord, to us as per the last order. It was hard at length. They have not received the paper, although my office has received it, it was not provided to me. And your lordship, so your lordship may give a direction to the registry to serve copy on us.
Copy to us.
The amicus, the counsel for the,
Yes, he's a paper for the
I'm
appellant.
here,
we've
Lordship.
got the paper book.
No, Lordship.
Supplementary.
Supplementary paper book, Lordship. Lordship, kindly produce the order dated, Lordship, 23 to Lordship. 23. It will
Mhm.
clear, Lordship. Last paragraph,
We
Lordship.
have a meeting at 1:15 or 1:20.
Let me sign.
Supplementary is waiting. Supplementary paper book is waiting.
It's there, your lordship. we have
The
checked.
record it-
Learned counsel for the parties submits that they are yet to be provided copies of the supplementary paper book.
It was provided to us in the office, but the office isn't provided to me. They have not received it.
I am appearing for the
Informant as well as the appellant.
Okay, then just say learned counsel for the appellant as well as learned counsel for the
Respond number 2, inform.
respondent who submits that they are yet to get a copy of the supplementary.
Supplementary paper.
Registry is accordingly directed to furnish copies of the supplementary paper book. to the learned counsel for appellant. as
All the
well as-
parties, it may be provided.
To all the parties concerned. When do you want?
क्या करूँगा? Any date government.
After 2 weeks, Lordship, any day.
2 weeks.
Lordship,
Lordship, item number 7.
7 is what?
7, 1 appeal against conviction, 1 appeal against acquittal, your lordship. There are 2 appeals.
arising out of same judgment.
Yes,
Seven.
arising out of same
One
judgment.
conviction, one acquittal.
Yes.
So
Lord, in this case, my lord, paper book we have received, but we have when we go through it, my lord, I have found that internal pages of the judgment, the even number pages are missing from the paper book, my lord. All even number pages, say 2, 4, 6 internal pages are missing.
so they have to again,
Yes, my lord.
where's the paper book?
Paper book is there, my lord. I have examined the record also, my lord. In our paper book also it is
In,
missing.
in which case?
My lord, in
Which one?
8, my lord, item number 8, my lord.
Oh,
You
it's
mean-
their appeal against acquittal.
Appeal against acquittal, criminal appeal number 162 of 2021 along with
No,
167.
no,
and
which
80.
is the case where the paper book is?
Paper book is same judgment, my lord.
Huh.
167 and 160, sorry, my lord. This item number 7 and 8, same paper book. Judgment is also same judgment. But internal page shows, my lord, the even number pages are missing.
Give a copy of the paper
Oh,
book.
said appeal.
Lordship,
94
judgment
crores
starts
that
on
is
page
supposed to-
94, Lordship, in paper book, Lord.
So it would, do number two missing.
Page starts from 94, Lordship.
page,
Starts from 94, Lordship. With paper
Yes,
book.
yes, my lord. Start from 94.
In bottom, Lordship, page number is there, Lordship.
yes,
Internal pages are given in bottom, my lord.
One,
Lordship will
three,
find that
five,
all even number pages are missing.
up to which page?
Up to 115, my lord.
Total 43 pages, Lordship, in judgment.
Yes.
1 to 15, no?
Yes, my lord. 115.
Okay, learned counsel with the parties submits. That page, that from page 94 to page 115 of the paper book. There are some defects. Stop, stop. On perusal of the same. We are also of the opinion that there are some defects in the paper book from page 94 to page 115. Registry is accordingly directed to, what will they do now?
My lord, let them rectify it, my lord.
To rectify the defects in the paper book
Yes,
from
sir.
page 94 to page 115
Lordship.
and list the matter again after 3 weeks.
Lordship,
Lordship.
3 weeks, Lord.
My lord, that's all. Advice.
Okay.
You heard me. Just I'll summarize today, and if necessary, after they reply, I'll reply it. Tomorrow or any date. Since it's a pattern matter, I don't want to keep it pending more. Well, here, huh? People, my lord, at the cost of repetition, my lord, again, lots of my lord here. My thrust is that his disqualification. Because scope of site admitted by R4 in his my lord counter, that R12, who is the candidate selected, he had no qualification to be appointed because in scope of site, there must be minimum 10 publications as per the UGC regulation. UGC regulation, yeah. And UGC regulation is already submitted to your lordship, my lord, page 61. So that is one first point. Secondly, my lord, even under the guidelines for my lord marking as prescribed by the director of higher education, in the objective side also, I have given less marks. Suppose I have got 13 years of administrative experience. I have given 8. R12 got only 8 years. He has been given 8 because there it says 1 year, 1 marks. Maximum is 10 marks. I may have 20 years of experience, but I will not get beyond 10 marks. So the objective side also, I have been given 8, 7, 8, 7, even lesser than the R12, who has got only 8 years of experience, administrative experience, admittedly, by his own admission. There is another smaller. So in marking also, there is, since I have lots of kindly note, my lord, one thing, series of Supreme Court decisions are there. The selection committee's marking or selection is sacrosanct, unless there is allegation of malafide and malafide is shown.
Yes.
There is there. Otherwise, your lordship will not touch it. Because your lordship is not sitting as a appellate authority over the selection committee. That is final. But here, my lord, what happens, my lord, if I am to get for administrative experience, there is objective marking, not subjective. Subjective, your lordship will give anything. The committee members give anything, that is up to them. There also, if I get 10, there are 9 members, 10 marks each, then I get 90. And he would get only 72, the R12. There is malafide. And particularly, I have alleged malafide against one gentleman, Professor Deepak Sharma. He was throw out against me, that I have also given. And then, my lord, in the counter by R4, my lord, and I have also already narrated, my lord, last time, my qualification, I am a doctorate degree guide. Under me, 3-4 students have come out and got PhD degree. The R12 is nothing. Even there is no clarity, my lord, whether he obtained doctorate with the permission of the authority or not. Otherwise, he will be liable for misconduct under Rule 13 of the conduct rules. That is not there. And the affidavit filed by, counter affidavit filed by the 12 is totally blank, my lord. He doesn't say anything. He simply goes on denying. No specificity. Your lordship only see the affidavit by R12. Counter affidavit. There, whatever I have alleged in my petition, he doesn't say anything. How far he is qualified, he doesn't say. When he obtained the PhD degree, he doesn't say. Even he doesn't say, my lord, how much of experience he has got, administrative, that also he doesn't say. So, my lord, he admits what I have contended in my petition. And if he does not deny especially, then a lot of knows one Nasim Banu's case, 1993 Supreme Court. That amounts to admission. Then, my lord, the selection meeting was held, my lord, on 11/4/2022. In the selection meeting itself, I found, my lord, the members were biased. So immediately on 13, my lord, 13/4/2022, I submitted a representation against the impugned resolution that 11/4/2022. But the resolution was yet to out because I came to know that R12 was going to be selected. So first time I pointed out the malified process of selection. The very decision-making process was illegal. 11 was the my lord selection committee meeting where I faced the interview along with the other candidates. And 13, immediately I point out that this is biased selection. So you'll also because that's why I'm pointing out there must be allegation of malified and biasness. Then in individual marking, my lord, I will also kindly see annexure B of the counter affidavit by R4, page 77 onwards, and consolidated at 86. Running page 77 onwards, my lord. There you will also find the differences. It is a bit complicated, my lord. If necessary, I will give a short note after the hearing is concluded, my lord. 77 onwards. Even on objective matter, yes, objective matter, my lord, I am Ranjit Sharma. I am given 5, he is given 7. Column number 1, 2 is not necessary. Administrative experience, I am given 8. Column 3, he has also given 8. He has given 8 years only. I have got 13 years. Same, but I should get the high maximum marks. 1 year, 1, because page 29 annexure E is the my lord guidelines procedure for selection of principal by DSE 29. The marking pattern is there, annexure E. Then again, column 4, I have given 5, he has given 7. This one, ability to plan administrative program, program. I am principal for the last 3 years. I have given 4. He was not principal, he was simply professor. He has been given 4. So, my lord, here also there is difference. And the next page, each individual in the same way. And consolidated is my lord, page 86. Just one thing more I want to point. And page 80, my lord, Deepak Sharma. Lots of kindly come to Deepak Sharma, the selection committee member, my lord. It is his individual marking.
Yes.
Second column, he has been given 5, I have been given 5. Third column, where I should get 10, he has given 8. I have also been given 8. Then fourth column, my lord, I have given 2. He has been given 5. And fifth column, I have been given only 1. He has been given 4. Sixth column, I have given only 2. He has given 4. Seventh column, I have given 1 only. He has given 4. So that way, his calculation comes to for him is 75.99. Mine he has shown is 51.47. But your lordship's calculates his marks even with this marking, then I get 53.94 and he gets 72.98. There also in calculation also is made wrong. Page 80. This is Deepak Sharma. Every page also files such defect. and 86 is the consolidated. They have shown me only 51.6%. And he has given 69.86
Page 86,
yes, 99.
annexure D.
Annexure, yes, the series, 86. Maybe your lordship, I think that page, my page and your lordship differs by 1 or 2 pages. Consolidated. In the top, it is a consolidated statement.
It's all comparative statements,
Yes,
all comparative.
comparative.
Where's the consolidated?
Consolidated, my page, it is internal page is 26, internal page is 26. The running page is 86. Internal page is 26.
Yes.
Yeah. You also can see. Yeah. Altogether, they have given me 51.6 and he has given me 69.99, almost 70.
No, you've been given 62.30.
86, my lord? Yes, yes, 62.30. Oh, yes. And he has given 69.99. If I am given full marks in the administrative expense alone, then 18 marks will be added. 62 plus 18, I would be getting 80.30 marks. Am I clear, my lord?
Yes.
Because I am entitled, because it is objective marking, not subjective. So 1 year, each year, my lord, page 29, next year you show the marking pattern of the DHE. That 1 year in explanation, 1 marks. I've got 30 marks. So, my lord, I should get 80 point. Here, 9 members were there, 2 marks each. So I will get 18 more, 62.30 plus 18. I will get 80.30. Totally malified. That's why I'm alleging malified. The procedure followed is illegal. Then, my lord, now you will also kindly come to the reply by counter by R4. Just 2 minutes. Yes. This is the statement R4. So lots of kindly come to his paragraph 8 of the R4 statement. Counter. That starts at page 60, my lord.
Who appears for R4?
He's in a change of the appears, he will do tomorrow.
Chowdhury sir.
Yes.
And anybody for the
R12.
What do I pay for on behalf?
higher education? Okay, all right. Continue.
Yes. Now let's kindly come to yes, come on. Paragraphs of mark ABCD. Page 69. Page 69, my lord, running page, and their internal page is 9.
Para?
Para 8. That is a crucial para, my lord, for us. Page 61. That while denying the statements made in paragraph 11 of the petition, the answering respondent begs to state that the API score of the respondent number 12 is 256. That is all right. Mine is 316. Much higher API score. The respondent number 12 has 12 numbers of research papers. This is totally false, madam. Published in journal with Scopus site I brought. That is annexed with me by us in his name. whereas the minimum requirement is 10. He admits 10 should be publications in the scope of site. Now, my lord, scope of site is our reply M1, M2. Page 131. Running page, my lord, and
Annexure, her pages are not telling.
yes, my lord, annexure M1. M1.
That is page 129.
Huh?
129. Page number 129.
One to
Yes.
yes, 2 pages are different, my lord, because we have marked the first page also, there are 2 pages are different.
Okay.
Running advance. M1. It is, my lord, the side of the R12, that's 12. We'll also kindly mark it.
Oh,
He has got only 9 of metric overviews, 9. First column,
where is
left
that?
side, top.
Yeah.
They have also got, my lord.
Yeah.
This is, you know, Utpal Jyoti Mohanta, R12. It should be minimum 10. Then more good, more good. And mine is page, you will also believe 131 page. Mine here 133. M12.
Hmm.
This is Sharma Ranjit, I am prisoner. Page 129, your lordship's page. I have got 19 metrics overview. 19. And he has got only 9. And I have a document authored 109 articles and books. He has got only 29. That is not counted, only the metric overview is counted, my lord, in this course side. So he is not qualified to be even selected or called for interview. Now the UGC regulation, from it is stated regulation, my lord, from the 1956 UGC Act, on section 14 and 26 of the Act. I think your lordship got one. It is copy was submitted. Yes, madam. Your lordship will kindly come to directly to page 61.
Page 61.
61. Your lordship, my lord.
Yes.
Page 61. College Roman V, my lord. 5. College principal and professor's grade. Eligibility. First must be PhD. Professor issues a professor with a total service experience of at least 15 years teaching, research in teaching or research in university, colleges and other institutions of higher education. Then, my lord, 3 is important. Minimum of 10 research publications in peer review. Peer review. This is important. I have got 19 peer review publications. He has got 9. Minimum 10 research publications in peer review or UGC listed journals. And that is clear from the scope of site. And minimum of 110 research score for the API score. I have got 316, he has got 256. Yes. So these are 4 has fully damaged the case of the Resolution 12. Own admission, my lord. Now I will also kindly, I will just now sum up, my lord. You will also kindly come to the counter affidavit of the respondent number 12. Yeah. In paragraph 11, I have said about my qualification. And to that, in paragraph 8 of the counter by the respondent 4, which I have already shown to your lordships, there the R12 was 4 has said on behalf of the R12, he is the member secretary of the selection board, R4, for whom Mr. Chaudhary appears, that he has got what is the requirement? 10 is the minimum, but from the scope side, it shows it is not 10, 9. Now, through this paragraph, this gentleman, R12, who is the main party, whose appointment, selection appointment I have challenged, SL here. My lord, he is, how he replies. That the statement made in paragraph 11 of the writ petition, the answer respondent denies the same and further states the same in misconceived and baseless. It is asserted that the answering respondent possesses the requisite qualification to be appointed as the principal so-and-so. It is further stated that in pursuant of the advertisement issued by the concerned authority, the answering respondent submitted the application so. He doesn't say. He totally silent. That means if he doesn't deny especially that yes, I have got 10 minimum scope site publications, peer review publications, it amounts to admission. He must be specific because I have specifically said. And R4 also on his behalf said that he has got there should minimum 10. So, my lord, an entire evidence also there is no specific denial, simply deny. And in one paragraph he says it's the responsibility of the petitioner to prove it. I am alleging. Now you show yes, you are eligible. He doesn't say so. So, my lord, yes, that if not denied respectful, my lord, then it amounts to admission, my lord. The judgment of Supreme Court 1993 that I will place on the ultimate day of conclusion. So this much is today, my lord. Let the reply tomorrow, then I will, if necessary, I will counter back.
Tomorrow may be a bit difficult. We can have it on Thursday.
Thursday.
Thursday is a hearing day.
Yes.
But RP Sharma, then it's
And record was called for, my lord. Answer here.
counsel for the petition. On request made on behalf of Mr. Ken Chowdhury, then the senior counsel for response number 4. Day after tomorrow. This is the matter on 23rd.
Obliged, deeply obliged.
Item 2, order.
So new matter.
May it please, Lordships. Lordship may perhaps recall these the admission matters which were pending with your Lordship from Navodaya Vidyalaya Samiti. Lordships, in one particular matter, in the admission of class 9 student, your Lordships had directed us to give admission to that particular child. Lordship, there was an inadvertent error on our part in placing certain facts which we could not place properly before your Lordships, and perhaps that is the reason why that particular order was passed. If I may take your Lordships to the few points which have come out. Lordship, what has happened is basically Navodaya Vidyalaya Samiti, later on we have come, I was also instructed about it later on, that the Samiti itself is the scheme of the Samiti is based on district wise. Each district is targeted and the students of each district are to be taken into that particular district only. The entire scheme of the Samiti itself is a lateral entry scheme. That aspect of the matter, although we had produced a particular document before your Lordships, but perhaps we could not place the actual relevant portion of the of that particular letter. If I may just take your Lordships to page 58 initially.
Page
58, annexure. This is page 58 is a part of the annex writ petition, your Lordships. It is annexure A, Collie. It starts at page 32. Page 58 is the scheme, the prospectus command. Lordships have got it?
yes.
Lordships, this is, I'm just reading clause 2.3. To serve, this is the admission test for 2022-23 where the child had applied, your Lordships.
to serve in each district as focal point for improvement of quality of school education in general through sharing of experiences and facilities. Your Lordship will note the first sentence, to serve in each district as focal point. Thereafter, Your Lordship, the next page, page 59. Clause 5, Your Lordships. How to apply. Online applications may be submitted through NVS headquarters website, so and so. Last date to apply for class 9 lateral entry test is 31st October 2021. This is the aspect which we inadvertently could not point out before, Your Lordship, that it is a lateral entry test. It is for that particular district itself. Now, in the case of this particular child, what has happened is that he's a resident of Dhubri district, but he had studied in the last 3 years. He's been studying in Kamrup rural area. And so therefore he has a rural area certificate, yes. And based on that rural area certificate, Your Lordships had given us a direction that since he is fulfilling the criteria that he's studied from the rural background, you give him the admission. The Lordships will also perhaps recall in another set of matters, the Honorable Bombay High Court had held that any child who is trying to apply for admission will have to satisfy a twin test. The twin tests which have been laid down is the first thing, that the child has to be from the rural background and from a government recognized school. And the second test is that he has to be a bona fide resident of that particular district. So those are the twin tests. That test was thereafter also taken up to the Supreme Court, and the Supreme Court has upheld the validity of that twin test, which was laid down by the Honorable Apex Court. But that was in the context of the class 6. I must be very fair with Your Lordship. That was in the context of class 6 admissions. Now, class 9 admissions are only an extended addendum of whatever are the residual vacancies in a district. Only those are advertised for class 9 admission. It is not, because they are fully residential schools, Your Lordships, the Jawahar Navodaya Vidyalaya, and therefore all the vacancies are normally filled up in class 6 itself. Whatever 1 or 2 or 3, 4 vacancies which come up in class 9 are residual vacancies, and therefore they are also district targeted. This aspect of the matter, Your Lordships, was not perhaps in our written statement also, in our affidavit in opposition. We did not bring into the lateral entry part was one thing which we had missed out, Your Lordship. And therefore the error was on our, we could not place the facts before Your Lordships in a proper manner. And hence the error has occurred. It is a painful thing for me to say that it is a child's admission and we are having to do this. But the reason why we are having to file this review is because Your Lordship's order might be treated as a precedent for other cases. And then it might become difficult for us. So that is the only reason why we are here before Your Lordships for this review petition.
Who is the order?
Lordships will find it at Annexure B, page 98. Oh, maybe. No, Lordships, one moment. Order this no, Lordship, Annexure H, page 134 to 138. 134, Your Lordship, just starts.
134.
134. I'm reading the portion at page 136, Your Lordships. Somewhere in the middle, page 136.
Yes.
The respondents have filed, I'm reading the second paragraph, Your Lordships.
Yes.
The respondents have filed their counter affidavit, and therein it is stated that the son of the petitioner was born in Dhubri district and his parents still resides in the same district. However, as the son of the petitioner used to live with his maternal uncle at Goraimari, which is in the district of Kamrup, rural Assam, and his birth certificate also shows that the permanent address of the petitioner's son is Dhubri, his case was rejected with regard to the residential status as he did not belong to the same district wherein the JNV Rangia is situated. Ms. Chaudhary Lennox so-and-so also placed the instructions received by her, later dated so-and-so, and the relevant portion reads as under. In this connection, it is informed that the admission in class 9 in JNVs through LEST, this is the lateral entry selection test, Your Lordships. LEST is the lateral entry selection test. Although the letter was placed before Your Lordships, however, we could not produce the entire scheme of the Navodaya Vidyalaya Samiti, which I have annexed now in this review petition. Is for the vacancies arising out of the admitted students in class 6, and district specific merit list is prepared. Hence, the same criteria of residence in the same district is applicable for admission in class 9 also. In fact, Lordships, every year, all these admissions take place in NVS, and it has always been the norm that a list is always prepared district wise. It was only in this particular year that someone decided to file certain cases saying that, we have been residing in some other district, although we may have been a permanent resident of another district. And that was put to challenge before several courts all over India. And ultimately, the Honorable Apex Court has upheld the twin test, which was stated by the Bombay High Court. That judgment also I have annexed in case your lordship want to go through it. The difficulty on our part, like I said, your lordship, is only that much that if we give admission to this one particular child, it is painful for me to say so because of the admission of a child, your lordship, we should not object to so much to it. But the difficulty is that if this is treated as a precedent, then it might become difficult for us. And the other aspect which I could just point out to your lordship is page 111. That is the scheme of the Navodaya Vidyalaya Samiti, Annexure E, page 111. This is Navodaya Vidyalaya Samiti was formulated in the year 1987, your lordships. And this is the scheme which was placed before the parliament before the entire thing was recognized. I am taking your lordships to page 114 for a moment. Clause 4(3), your lordships. Maybe I should start with clause 4, your lordships. It has therefore been decided to set up residential schools to be called Navodaya Vidyalayas, on an average 1 in each district during the 7th 5-year plan. The broad aims for establishment of NVs are to serve the objective of excellence, so and so, so and so. Then your lordships will come to clause 3. To serve in each district as focal points for improvements in quality of school education in general through sharing of experiences and facilities. And thereafter, your lordships, the next page, page 115, clause 8. The basis of admission to Navodaya Vidyalayas, clause 8, your lordships, have your lordships got it?
Yes.
Will be a test conducted in the concerned district in which all children who have studied in and passed class 5 from any of the recognized schools of any tehsil or block in that district would be eligible to appear. The scheme behind the Navodaya Vidyalaya Samiti was each district may have its own language barrier. So therefore, to focus on the rural areas of each district, and so that each child from each district gets an equal amount of recognition. The scheme of Navodaya Vidyalaya was for threefold languages, your lordships. One was the regional language, one was Hindi, and one was English. These 3 languages. Now, your lordships are aware, even in Assam, the local language in Dhubri district is different, and the local language in Rongya district would be different. So the test which is conducted in the local colloquial language of that particular district, although it isn't within the state of Assam, but therein also several different dialects, different connotations come into the language. So the test which is conducted is a lateral entry test for each district, and that aspect of the matter we could not place in a very proper manner before your lordships when your lordships were passing this judgment. And thereafter, your lordships, I'm taking your lordships back to your lordships order, taking into account the rural certificate of the child at page 137. Page 137, your lordships.
Yes.
This court has considered the rural certificate issued to the son of the petitioner, namely Arfan Azam, by the circle officer so-and-so, which indicates that the son of the petitioner studied in class 8 in Adarsh Ahom Jatiya Vidyalaya, Goraimari block so-and-so, which belongs to rural area of district Kamrup. A perusal of the eligibility criteria provided by the JNV for admission to class 9 for the so-and-so against vacancies clearly indicates that a candidate should be studying in class 8 during the academic session so-and-so in one of the government recognized schools of the district where JNV is functioning and where the admission is sought. Now, this is where the error has occurred, in lordships. It was not only that, it should have also be consonance. It should have also been in consonance with the twin test which has been laid down by the Honorable Bombay High Court, lordships, and as upheld by the Honorable Apex Court. The rural certificate issued by the so-and-so clearly indicates the petitioner's son was studying in class 8, which is located in the rural area of district. On perusal of the eligibility criteria and rural certificate issued by the so-and-so clearly indicates that the petitioner's son studied in government recognized school in the district where the concerned JNV is functioning, and the petitioner's son has sought for admission in the said JNV. Therefore, this court is of the considered opinion that grave injustice has been caused to the son of the petitioner by denying him admission in class 9 for the session 22-23. Accordingly, the authorities of the concerned so-and-so is directed to admit the son of the petitioner to class 9 for the session so-and-so in JNV Kamrup Rongya within a period of 2 weeks from the date of receipt of the copy of the order. Now, if your lordships, if I may just take your lordships to the judgments of the Bombay High Court and the annexure F, your lordship, page 121. It starts at page 121.
Yes.
Page numbers, lordships will find it at page I'll take your lordships to page 129, paragraph 9. I'm starting from paragraph 9, page 129, your lordships.
Yes.
Lordships. Clause 4.1 under the caption "Who is eligible" also provides insights for interpreting the clauses. It states that only the candidates from the district concerned where the JNV has been opened are eligible to apply for admission. The general rule under the said prospectus is that only the candidates from the district concerned where the JNV has been opened are eligible to apply for admission. Clause 3.6 further provides the children selected on the basis of district will be admitted only in the JNV located in the district from where they are studying in class 5 and appear for the JNV ST. That is the selection test. Reading clause 3.6 and 4 conjointly and harmoniously, irresistible conclusion that can be drawn is that a candidate will be required to satisfy the twin test for being eligible to get admission in the JNV. The first test, your lordships, the candidate should have passed 5th standard from the district where the JNV is located, and only the candidates from the district concerned where the JNV is open are eligible to apply for admission. The condition of residence certificate in the prescribed forma in case of NIOS, that is the open category student, your lordship, that is candidates should obtain B certificate. This is not really relevant to our case, your lordships. Your lordship will just skip the next few lines and come to the towards the last of the page, your lordships. For the said purpose, additional precautions appears to have been undertaken. The general rule of eligibility has been laid down in clause 4.1. Clause 4.1 starts with the term only. It states that only the candidates from the district concerned where the JNVs are opened are eligible for admission. The word only implies that the students other than the district where the JNV is situated are excluded. No other interpretation is possible. We cannot persuade ourselves to accede to the arguments of so-and-so, the learned advocate for the petitioners, that even though the student may not be the resident of the same district where the JNV is situated, and if he has passed 5th standard from the district where the JNV is situated, is eligible to be admitted. Such an interpretation would be against the object and the tenor of the clauses in the prospectus. The aforesaid discussion leads us to conclude that the candidate seeking admission to the JNV must satisfy the twin test. Number 1, he must be studying in class 5 in the government aided or other recommended schools or B category schools in the same district where the JNV is situated. And number 2, he must be a resident of the same district where the JNV is situated and is seeking admission. So the child in the instant case does not fulfill the criteria at the test number 2, your lordships. Although he fulfills the criteria of the rural background, but he is a bona fide resident of Dhubri, but he has studied in the rural background in Kamrup, Rongya. And that is the difficulty insofar as the NVS authorities is concerned, your lordships. Hence, we are before your lordship by way of this review petition. I may also take your lordships to the Supreme Court's order, which is on the next page. It is a very cryptic, short order, your lordships. This is, I'm reading from the bottom order. We are not inclined to lordships 132 page towards the bottom. We are not inclined to interfere with the impugned order. The special leave petitions are dismissed. However, we make it clear that the department, qua the petitioners for seeking admission in Kolhapur and Ratnagiri, will not apply in the given facts of the case for the next year to work out the equities. Pending applications stand disposed of. So insofar as
Page 132.
132 and 133. Yes, your lordships. Annexure G.
I don't have 133.
Lordships, I completely apologize.
No, just
I have also not.
Oh God. Yes.
Page 133 is missing in my copy.
Oh, I deeply apologize, your lordships. Perhaps during photocopy it may not have been there. If I could just give my part of the order to your lordships. Amar here code, where's the petitioner copy? Tate extra asal na hai? फोटोकॉपी दिया ही नहीं. So in the particular matter, Your Lordship, what the apex court had done was that they had given the liberty to the authorities to for that particular districts to work out the modalities as we deem fit. But otherwise, the appeal which was preferred by the petitioners was dismissed, Your Lordship. And so the order of the Bombay High Court was upheld. Your Lordship will now note the names of the parties: Shubham Vijay Patil versus Navodaya Vidyalaya Samiti.
Yes.
That is my humble submission. If your lordships would want to go through such, I would like to just place 2 or 3 judgments also before your lordships. Insofar as review is concerned, when and how the powers of review can be exercised by this honorable court. Pehle mujhe wo 1991 wala do. There are only 3 judgments which I'm relying upon, your lordships. 1993 sub book list diya hua tha. Huh? List of books diya asle rati. 1993 supplementary 4 SCC. Supplement diya nahi. Supplementary 4 SCC 595. Lordships, I'm placing my own book with your lordships. Kya extra copy bhi lete hain aap? Unbelievable. Yes. तब से बैठे हैं फिर से. Paragraph 18 and 19. Sorry. Move extra copy to 92. No, sorry. Ulai dibo pari ko nahi kitya. Huh? 1993 supplementary 4 SCC.
You don't have extra copies.
Lordships, unfortunately, I do not, because I
Now,
thought I
then
had.
can we
Lordship,
have
in
it on Thursday, day after tomorrow? You come prepared with the rulings. I've
Lordship-
heard whatever I've heard.
Lordships,
How
I'm-
about you? How long you'll take?
I will not take much time, my.
Practically,
Lordships, I will just take one
the-
more decision, and that is all, your lordships. I'm not taking too much of your lordship's time. This Lily.
no, I don't have the decisions. with me.
This decision, which I was referring to, has also been relied upon in another matter, which is what I will place before Lily Thomas to Disa Nanai judgment to 2006 SCC. Hey to Disa 2006 SCC, page 224. Paragraph 52 of this judgment, your lordships.
Yes.
The dictionary meaning of the word review is the act of looking, offer something again with a view to correction or improvement. It cannot be decided that the review is a creation of a statute. This court in so and so case held that the power of review is not an inherent power. It must be conferred by law, either specifically or by necessary implication. The review is not an appeal in disguise. It cannot be denied that justice is a virtue which transcends all barriers, and rules or procedures or technicalities of law cannot stand in the way of administration of justice. Law has to bend before justice. If the court finds that the error pointed out in the review petition was under a mistake, and the earlier judgment would not have been passed but for the erroneous assumption, which in fact did not exist, and its perpetration shall result in a miscarriage of justice, nothing could preclude the court from rectifying the error. Lordships, they have further relied upon that S. Nagaraj is the case which I was trying to rely upon before your lordships. In paragraph 19, they have quoted, review literally and even judicially means re-examination or reconsideration. Basic philosophy inherent in it is the universal acceptance of human fallibility. Yet in the realm of law, the courts and even the statutes lean strongly in favor of finality of decision, legally and properly made. Exceptions, both statutorily and judicially, have been carved out to correct accidental mistakes or miscarriage of justice. Even when there was no statutory provision and no rules were framed by the highest court, indicating the circumstances in which it could rectify its order, the courts culled out such power to avoid abuse of process or miscarriage of justice. So, lordships, it is very clear that the basis of review powers are otherwise, even if statutorily not provided. Of course, we are under Article 215, your lordships, and therefore your lordships can certainly exercise the powers of review. There are certain cases where perhaps the review is not statutorily provided. But we are here before your lordships under Article 215, and therefore your lordships can totally exercise the powers of review for correcting a mistake which is pointed out, your lordships. One last decision, your lordships. This is 2001 SCC, page 666. This is MM Thomas versus State of Kerala. This is a very small cryptic judgment, your lordships. What it basically says is that the High Court is a court of record. And considering the fact that all records are always maintained in perpetuity in the High Court, therefore the High Court should always keep its records clean, and for that, if required, a review should always be entertained. I am taking your lordships to paragraph 14 of this judgment. Lordships, the High Court as a court of record, as envisaged in Article 215 of the Constitution, must have inherent powers to correct the records. A court of record envelops all such powers whose acts and proceedings are to be enrolled in a perpetual memorial and testimony. A court of record is undoubtedly a superior court, which is itself competent to determine the scope of its jurisdiction. The High Court, as a court of record, has a duty to itself to keep all its records correctly and in accordance with law. Hence, if any apparent error is noticed by the High Court in respect of any orders passed by it, the High Court has not only the power, but a duty to correct it. The High Court's power in that regard is plenary. That is my humble submission to your lordships. I am here before your lordships for the review of the order which has been passed by your lordships and make necessary corrections thereon.
It will be basically rejection of the writ petition.
Lordships. It might not. Lordships, off the record. If your lordships are inclined to say that this judgment will operate in personam, not in rem, we are okay with it. That is.
That's what I was thinking also.
Um,
It should not be a precedent.
it should not be treated as a precedent. If your lordships will correct the error to that extent and say that we have noted that certain errors have occurred, but since the direction has been issued and the child has been awaiting, perhaps therefore in the interest of justice, this may not be treated as a precedent, it may be just treated as a judgment in person. That perhaps your lordships may. I would be deeply obliged to your lordships if that direction is also granted. As a special case, because that liberty, the Honorable Apex Court had also granted by way of that page which I have just raised. That liberty was granted by the Honorable Apex Court. Your lordships can also quote that perhaps and say that since the Apex Court has also granted that liberty, in view of that, we are inclined to, lordship will not record my.
No, no.
As my learned friend has submitted, if your lordship passes the order that the child may be admitted and it cannot
No,
be
no.
treated as a precedent, then I have no argument.
That's not my, that is off the record.
So my lord, the order
Oh, fine.
impugned by my learned friend is passed on the point of law that if the eligibility criteria is fulfilled, then the admission is to be given. Categorically, it is held by this honorable. Now, regarding their review, may I take your lordship to the particular provision of review? Order 47.1.
I will hear you. But MS RS Chowdhury, Land Council for the review petitioner. Also heard Mr.
S. Alim.
S. Alim, Land Council for the opposite party number,
One, your lordships. Oh, no, just one. Your lordship.
opposite party number 1.
Yes.
Anybody union?
No,
No,
your lordship. There's formal party, your lordships.
by this new para, by this review application. The review petitioners, i.e. Navodaya Vidyalaya Samiti, is praying for review of the order. Is it order or just
Lordships, 6/2,
of the order dated
6/2/2023,
6/2/2023,
page 135, your lordship.
passed by this court in WBC number 5429 of 2022. On the ground that this court, while giving a direction to the review petitioners to admit the respondent number 1 oblique writ petitioner in class 9 for the session 2023-2023 2022-2023 in the Jawahar Navodaya Vidyalaya, Kamrup, Rangya, this the review petition had failed to apprise this court with regard to the, where was that paragraph? that-
Lordships, it is page 115.
With regard to the,
It starts at page 111. It is the scheme of the Navodaya Vidyalaya Samiti
failed to apprise this court with regard to the scheme
of Navodaya
of
Vidyalaya,
the Navodaya Vidyalaya scheme.
wherein clause 8, that is at page 115.
At clause 8. It is, where was that?
Page 115, Your Lordships.
Yeah.
The basis of admission to Navodaya
where
Vidyalaya.
clause 8 of the said scheme provides that the basis of admission to Navodaya Vidyalayas will be a test conducted in the concerned districts, in which all children who have studied in, and passed class 5 from, any of the recognized schools in any tehsils block in that district.
In
would
that
be-
district.
In that district would be eligible to appear.
Lordships.
So, she further submits, she further submits that, where was that lateral entry part?
Lordships, that is at page number 58, Your Lordships.
58.
Page 58 of the review petition. That is the prospectus cum application form.
Further,
It starts at
she
page
further
58.
submits that in the prospectus cum application form for admission tests in Jawahar Navodaya Vidyalayas for admission in class 9.
During for 22-23 session, Your
For
Lordship.
the session 2022-23,
Next page, page 59, Your Lordship, clause 5.
clause
Clause 5.
5 provides that online applications may be submitted through the NVS headquarters. And the last date to apply for class 9 lateral entry test is 31st October 2021.
Also 8.1, Your Lordship, where the word only is used, only candidates.
She also draws the attention of this court to clause 8.1 of the prospective cum application,
Lordship.
which provides that only those candidates who are studying class 8 during the academic session 2021-2022 in one of the government schools of the district where the GNV is functioning and where admission is south, are eligible. She submits that these facts could not be brought before the notice of this court, and therefore, as the son of the writ petitioner, respondent number one has failed to comply, has failed to what is it?
Does not belong to the same district.
Does not belong to the same district. He is not eligible for admission to class 9 under the
Lateral entry scheme.
under the lateral entry scheme at the NVS
Wrong.
Rangya.
Lordship.
Stop. Para. After hearing the learned counsel for the parties.
Your Lordship may also note the High Court order of the Bombay High Court as well as the Apex Court order.
Okay. Learned counsel for the writ petitioner has also drawn the attention of this court to
Uh,
the
Bombay High.
to the judgment order.
And it starts, it's annexure F, Your Lordship, starting at page 121, the effective portion of the order.
1 minute, to the judgment order
um,
dated
13/10/2022.
passed by the High Court of Judicature at Bombay in WBC number 9310 of 2022. Where the Bombay High Court
Page 131, Your Lordships.
has held that the candidate seeking admission to GNV must satisfy the twin test within bracket Roman 1. He must be studying in class 5 in government or government aided or other recommended schools, or
These are NIOS schools, Your Lordship. Lordship will not note that in
or
the same district.
and number 2, Roman 2, he must be resident of the same district where the GNP is situated and is seeking admission.
Okay.
Said judgment was appealed before the Honorable Supreme Court, which was however dismissed
On 4/11/2022, Your Lordships.
on 4/11/2022.
Page 132.
Well, however, by making it clear that the department the petitioners for seeking admission in Kolhapur and Ratnagiri will not apply the given facts of the case for the next year to work out the equities. Stop. After hearing parties and on consideration of the materials available on the court, as well as the judgment of the High Court of the Bombay High Court, as well as that of the Honorable Supreme Court, common. This court is of the considered opinion that is respondent number 1 the son or the father?
Lordship, they had filed the matter in the name of the son, represented by the father, Your Lordships. Arfan Azam, represented by his natural
That-
guardian,
Respondent number 1.
Your Lordship will write note that only, represented by his,
Who is represented by his father. Is waiting for admission
Lordships.
for a long period of time.
Lordship.
I see no reason to modify the order. Dated,
Yes, ma'am.
dated,
Given order the case, 13/10/2022, Your Lordship.
13/10.
No, Lordship. 6/2/2023, 6/2/2023,
2023,
in WPC
passed by
5429.
this court in WC 5429/2022. How, it is made clear that the said order shall not be a precedent for other cases in future.
It may be treated as judgment in personam. If that line is,
The same shall be treated as judgment in personam. Stop. Accordingly, this review petition is disposed of.
I'm deeply obliged to Your Lordships.
Item 4, hearing. My lord, read petition dismissed or review petition dismissed?
Modify to the extent.
It will not be a precedent. I am not interfering with the order.
Lordship, this.
My lord. Obliged, my lord.
Well, there was a direction to file an affidavit on behalf of the government. Because of the ongoing budget session, my lord, the joint secretary was supposed to sign it, my lord. He has requested that by today evening, somehow he will send the affidavit. On Tuesday, my lord. Otherwise,
Not
he supports the
Tuesday, can
petition.
it be on Friday? Friday kori to Tuesday he matter to fix it, sir.
Or Thursday next, my lord. Thursday next.
Let it be on Friday, we'll take a chance, your lordship. These petitioners have been waiting for the last 6 years, your lordship.
Wait for another 1 day, 1 week. Third hour, Sina, learned counsel for the petitioner. Mr. B. Gogol and the standing counsel head department submits that he will be filing affidavit. That as directed by this court on 8/2/2023. Within the period of 2 days or 3 days.
3 days, by Friday.
3 days,
Time
one
of
day.
this to file.
Your lordship, let them file it by Friday and let the matter be listed on
Prayers a lot. List the matter again on
30th, your lordship,
Yeah.
Wednesday.
30
Not-
March.
Deeply obliged, your lordship.
Obliged.
Affidavit to file today. এখন তো তাহলে-